देखो मैं कॉपी यहाँ से करके देख। हाँ, गूगल ड्राइव। Item 301.
Yes.
Milord, the Balram Balla is the father of Ramsi and Ashok. He had two sons. And these three were involved in the incident. Milord. Now, what happened, Milord?
Now we are considering the plea of juvenility.
Yes, man, only.
If you have seen the affidavit of the state, it's completely bogus. Because now you are allowed to raise a plea of juvenility at any stage. These curatives come after we have dismissed the appeal. It's totally bogus. The affidavit says the birth certificate was dated 29 July 2019. It was issued on the basis of an online submission of documents. What were they? Were an affidavit, ration card, and Panchanama. Panchanama of the Sarpanch.
His own application.
And his own application. In 2019, he suddenly realizes that, he's juvenile. It's just a waste of time, for us and for everybody.
Kindly see, Milord, Ashok. He has been released, Milord, on this basis, Milord.
We are dealing with this case now.
Yes,
we are
Milord.
dealing only with
in this case, Milord, in this case, three accused, my brother Ashok and me and my father. So Ashok has been released, Milord. He has been dealt by this court, Milord. He was 1 year younger to me, Milord. We both are real brother. This is the order, Milord.
That has not been analyzed, subjected to scrutiny.
No, that SLP was dismissed. I was the counsel in that. In fact, I filed these XLPs, Milord. And thereafter, they engaged another lawyer. He moved an application, matter restored, and that was allowed, Milord.
Is now in.
The certification is on the basis of his own application. That has been looked at. In fact, the affidavit says that they went to all the schools, not only in that village, but in the outlying villages. They said, do you have any such candidate? There's no such candidate.
No, they say record is not available, Milord. Record is not available, Milord.
Then how did you manage to create it? Your application is
this is the certificate, Milord. He is in jail, Milord. Right now, he is in jail.
2019
Yes,
application.
Milord.
You applied.
Still, he is in jail, Milord. And another brother has been released, Milord. Both are, Milord, brothers, Milord. I am not asking about the father. He is about 87-year-old, Milord.
Will not recall his order in the case of the brother, but this is completely bogus.
In Sierra, Milord, kindly see in Sierra, Milord, kindly my lord has issued notice on the basis to verify. Now see page 5 of the reply. All school had provided that they don't have any record. And kindly see page 30.
Most important, how was that certificate issued in 2019 on the basis of his own online submission, his application?
No, kindly.
And the Panchanama by the Sarpanch. Panchanama.
Milord, everybody knows in the village, Milord, these are the old cases, Milord. Kindly see page 30, Milord.
This is how, actually, I'll tell you what, this is how the process of law is misused in our country. As a result of which one genuine person may also have to suffer one day.
They are illiterate person,
These are all cases of misuse. There's a little loophole created by the law, a little exception created by the law. Everybody wants to sort of now jump.
Milord, I can understand if it is in the
city. We have said that even after the dismissal of a specially petition, if you bring in a genuine document, definitely you will be entitled to a scrutiny by the court. But that's completely different from
what behind the bar.
Told us.
All three are behind the bar. Nobody is here, Milord, to look after, Milord. It is only cousin brothers, Milord. And both are real brothers, Milord.
The claim for juvenility has been exhaustively dealt with in the counter affidavit, which has been filed on behalf of the state of Madhya Pradesh. Full stop. The claim for the application for the issuance of a birth certificate was filed on 29 July 2019. Full stop. The documents in support of the application consisted of an affidavit, ration card, and Panchanama. Full stop. After careful scrutiny, it has been found that after careful scrutiny, it emerges before the court. The claim for juvenility is without substance, is without merit. Full stop. We therefore do not find any reason to exercise the jurisdiction in a curative petition. The petition is dismissed.
Milord, in fact, Milord, this is totally unfair with this person, at least. I can say that.
Be careful while filing such applications in the future.
Your Lordship, with your
Or did you
Lordship.
send an email? Send an email.
Your Lordship, we have already filed.
I'll attend it to it. When did you send the email?
Yesterday, the mail was sent, Your Lordship. Today also.
What time? What time? What time yesterday?
At 10:10, Your Lordship.
Right. So 10:10, you don't expect me. So is somebody being hanged or something?
Your Lordship.
Somebody is being evicted from the house. Then give me time until the afternoon to deal with the email.
This was mentioned actually on the 8th, Your Lordship allowed it on the 15th.
Send an email. What is the matter about?
We again mentioned it on the 15th yesterday, my
What's
Lordship.
the matter about?
Yeah, and we've
All right.
circulated to mentioning.
All right, I'll look at the email and I'll give them to you.
The urgency is before 19th, my Lords, because the trial court is proceeding. And
All
asking
right.
us to file it.
All right, then.
Item 14.
Please, my lord, I beg to refer to the petitioner.
Acha, 1 second. You are in 14?
Yes, my lord. 14 to 14.1.
एक ऐसा matters in out of turn. We'll take up matters from 1 onwards so that nobody feels they're taking any matter. What we'll do is we'll take a roll call. Seal number 1, which is the income tax group, will go on for the whole day. We have a few matters which are passed over from yesterday and therefore we had kept them today. We'll take them up first, then we'll go to 1 and then we can probably, the rest of the matters can either go to tomorrow or next week.
So that's 14 is yesterday's matter.
Right.
Yes.
We'll just, so that people, don't mention Ms. Jai Singh. I'll call up serial number 1. 1 second, serial number 1.
That's an item 1.
1, we will just hold it back. We'll start the matter in
No difficulty, Lordship.
10 minutes, we'll start.
No difficulty, my Lords.
10 minutes later.
Very
Item 2.
My lord, I'm in item 2. If your lordships are taking item 1 for the whole day, kindly discharge the board. That's all I
We'll
wish
do
to
that.
say.
We'll just see once everybody's assembled, we know that it's going on.
We'll be spending the
Absolutely.
whole day in
No,
court.
yes, of course. That's why we are calling out the matter.
May I also just request that this is the marital rape matter, item 2. We'd greatly appreciate if you could give it some priority.
Absolutely. That's why it's seal number 2 today. If it doesn't reach today, maybe tomorrow. We'll do something to work it out.
I believe tomorrow is not about
Holiday,
if I'm
yes.
not mistaken.
Thursday maybe. We'll see Thursday or next week we can take it
My
up.
lord, I'll wait for some time just to
We'll
see
just
how
see.
it.
That's why we are running through the board so that we'll be able to,
Very
relieve all the lawyers in 15 minutes.
Very well.
Three is the same batch.
3 is the same.
It's the same, my lord, 2 and 3.
Item 4.
4 is the restitution of conjugal rights.
Please, my lords.
We'll just,
One
Yes,
matter, a counter has been filed by the union. There's some other
the
enactment.
challenge to the restitution of conjugal
Lord,
rights.
I'm appearing in that matter
Fair.
also.
Same thing as 3. 3 and 4, we'll take one after the other. So,
Please,
Item 5.
my lord.
Item 5 pertains to income tax matter, TDS matter.
necessary. Item 5,
It's the tedious matter.
we'll just roll it over a little bit. But today, item 5, I don't think will reach today.
Yes, madam.
So what you can do is you can safely, we can keep it next Tuesday, I think.
Next week.
So that 5 we'll take up next Tuesday. Very interesting of the parish priests and nuns.
Item 6.
Obligement.
Item 6, my lords, I appear for the Madhya Pradesh High Court. This, my lords, pertains to the visually impaired candidate. So item 6.3, we moved an application for clarification, if my lords can. Well, there's an interview to be scheduled.
So we'll take it in on Thursday.
Very well.
Thursday correct.
Item 7.
Only the application, huh? Only the application.
In 6.3.
Yes.
Item 7.
7 for next, we'll keep it next week.
Yes, I beg to appear for respondents 3 and 4. I've received instructions to file my counter. Your Lordship should only grant me 2 weeks. Counter and
2 weeks for counter and we keep it on a specific day.
8.
I'm ready.
It's an 8, it's a very short issue. Your Lordship has issued notice, your Lordship should simply remand it because my writ, I seek no stay, I seek amendment, finding his amendment is valid. He says, I'll allow the amendment for an impossible payment. And that payment is not covered by a Lordship's earlier order.
Who's appearing in 8?
Your Lordship, really for
Union of India. Mr. Venkatraman, are you appearing in 8 by any chance?
8?
8, who's appearing for the Union of India?
Service is done.
8, somebody is appearing?
Item 8, Sipla.
We'll keep it next Tuesday.
Kindly put it next Tuesday.
Next Tuesday we
Can
can.
be disposed of on a remand.
Yes,
Your Lordship
absolutely. It's a
agrees.
short point.
Item 9.
This is the jet matter. Will your lordship have it next week as 5?
Next Tuesday.
Next Tuesday.
Yeah, next Tuesday.
Because
We'll
we
take it
finished
next.
off. There's further infraction during this
We'll
vacation.
take it up next.
Next week.
Item 10.
Kindly top of the board somewhere on the higher in the order.
Yes, yes. 10 को आप ऐसा कर लो. This is about the
Yes, roll up.
tax on the mobility devices.
Oh.
That is
AG
also
is to appear,
this
he's
one.
not in town.
Yes.
Next.
Uh,
AG is not here today.
Yeah. Next week we can take it. So till 10 को 2 weeks दे दो. 2 weeks.
Item 11.
Jet Airways.
9 may not reach today because we are starting an income tax matter. So we just thought we'll run through the board and 11.
Your Lordship, I appear for the petition. My Lordship, we requesting for next week, my Lordship.
We'll keep it after a little while. So we'll just keep it after 3 weeks so that we'll finish now.
Your Lordship, it pertains to reservation for the IPS. The UPSC mains would be this week. After that, the form would have to be filled. If we could have it anytime earliest convenient to your Lordships.
Can it come after 2 weeks?
Your Lordship.
All right.
12.
That's West Bengal matter.
West Bengal, after the income tax group, we'll start the West Bengal today. Let's see how long the income tax group is taking, or we'll then continue on Thursday or something like that. Will it be okay for everybody if we
This will be
take it on
nice,
Thursday?
but it may be abortive because nobody has filed a chart, nobody has filed a counter, more matters have come, your Lordship may have an incomplete matter. And Lordship may start the matter.
If it is kept back by.
Your Lordship gives a procedural direction
Complete.
to complete the pleadings and have the chart which the government was to give your Lordships, then Manoj, it will be
No
better to
count
take.
has been filed by the.
No.
Counter is 1 or 2 have been filed.
Who's appearing for the respondent?
Detailed order.
We are appearing for the.
You have not filed a counter? You want to go on with the?
Not get every copy, Malak. They are not only that, Malak, School Service Commission is also not filed anything. Because last.
You are appearing for whom?
I am appearing for the writ petition.
The original writ petitioner
The
before the
original.
High Court. And who are the other respondents in these?
School service answering respondent is the School Service Commission is the answering respondent. And they also filed the last occasion, Malak, remember, they says that the segregation list they are going to file, Malak, but till that, Malak, they are not filed.
You have a copy of whatever it files, the state government probably.
Where is the School Service Commission?
Just one. State has filed an NLP number one.
Application
So the state and commission are not filing any further affidavit, so it is for them to respond to the SLP.
Are you people filing your counters to the SLP or not?
It's not required. All they don't.
All right, we will give one opportunity so that nobody says we didn't give that opportunity.
Clear.
Yeah, we'll say that,
But state and commission also filed the SLP here. They have preferred the special petitions there.
yes.
Therefore, Lord, they are asking for the affidavits. Their stand is very clear in the SLP itself.
But the private writ petitioners before the High Court.
Private, they have not filed, Lord. They are the writ petitioners before the High Court.
So what we'll do is that we will give them an opportunity to file a counter within 2 weeks.
Smart.
If they don't, we will say the right to file the counter will stand closed. And we will say that, is it possible to prepare one compilation? Otherwise, it will be impossible, with so many lawyers appearing.
Nodal council this side nodal council, that side, no kind of.
Lord, may I just tell you, Lord, one thing?
I think
Lord,
the
in
commission will
Calcutta High Court, there are 50 petitioners. 50 petitions. Now, just one, that what has happened, Lord, in one affidavit, in one petition, one affidavit, another petition, another affidavit, one petition and one report, another report is another affidavit. All, Lord, it is really, Lord, I can try to do it, Lord, but it's really difficult, Lord.
Better if
Any
commission
report
does
is
it.
not.
The commission is more concerned, so commission should file the.
No, we are not, the commission is not concerned. Lord, we are.
All right, you tell us who will really
One
help
nodal
in.
council each side, Manoj,
Lord,
to nominate.
Your Lordships, may I suggest a.
Lord, we are, Lord, we are looking to these things to that commission,
Suggestion.
commission is changing, Lord, commission is changing their stand from time to time, Lord. This has created a great difficulties to us. Commission in Supreme Court said something else.
Now, you are appearing for whom?
Lord, I am appearing for the OMR disputed candidates. Group C, Group D, class 9, class 10.
So you are the candidates who will be displaced now as a result of the judgment.
Exactly.
So really speaking, you are on the same, same side as this.
May I just point out, Your Lordships, there will be 5 categories of people. The first will be, Your Lordships, the government. The second will be SSC.
1 second. Yes.
One is government, second is SSC.
Yes.
Third are the original writ petitioners whose grievance was that they were not selected due to all the malpractices that were followed. That will be class 9 and 10, class 11 and 12, and group C and group D. All the 4 categories subsumed in that. And group C and D. The 4th category, Your Lordships, will be
Yes.
people who were appointed and their appointments were cancelled. Yes, Your Lordships. And 5th will be the residual category who would have been appointed, but action yet not taken against them.
No.
And also, very well, also CBI, lastly. So these are the main stakeholders in the entire matter, Your Lordships, and I humbly submit that it cannot carry on in personam. This matter has to carry on in rem. So once these interests are before Your Lordships, represented before Your Lordships, rest of the people who want to file can file interventions. For example, today my petition is also a new SLP with a permission to file.
Now tell us this, who would be appearing for the government of West Bengal? Who is leading
I'm
the...
appearing for the government Bengal, and Astha Sharma will be the coordinating council from this side.
So whether Your Lordship, there are writ petitions or interventions or SLPs, the dispute is the same.
This is the main appeal, no?
Well, it's also in 12.27, we moved an application for.
Apart from that,
The name of the commission is West Bengal Central School Service Commission.
Full circumstance.
Right. Now, who's appearing for the School Service Commission?
Mr. Jaideep Gupta was
Mr. Jaideep Gupta.
Your Lordships, now SSC can file a common affidavit.
Yes, fair enough. Mr.
For
Gupta,
everyone.
you are appearing for the School Service Commission? All right, perfect. Now, the petitioners in the High Court who are not selected,
We are appearing for the, on behalf of the writ petition. Apart from this, all, my lord, West Bengal Board of Secondary.
so you are those petitioners who contend that the selections were vitiated by fraud.
Yes.
Right? You are in conflict with Mr. Dwivedi, are we right in making that assumption, right? They are the people who say that, look, we should have been selected. You didn't select us, you selected other people by fraud or whatever. That's their case.
No, that has not been, sorry,
We are not making any observation on merits. We are just trying to understand the lay of the party so that then we can make bring some order to the whole matter.
May I point out why another thing?
Now, how many lawyers are in that category?
So far as.
We can't number them, most of us are in that.
All right.
Just get another category minutes.
So you would represent class 9, 10, 11, 12, group C and group D, right? All right. Now, persons appointed whose appointments were cancelled. There we would have Mr. Vaidyanathan, Mr. Patwalia, Mr. Ramchandran.
So far as there are.
Well, there's also another subcategory. The subcategories of those people who were never parties in the litigation. And as a result of.
And whose appointments will be cancelled, right?
Yes. Without being a party.
Right. Fair. But whose appointments would be cancelled now? All right. RPI is also on the same. All right.
तो ऐसा मोटा चाप नहीं आ जाना
मतलब there are
चाप नहीं आ जाना
There would be categories concerning.
And persons who would be, persons who could be appointed and no action has been taken. Who are those people? Those are the people whom the government had said that all right, we will extend some benefit to them, but eventually they were not appointed. So one second, just 1 second. If everybody keeps on talking out of turn, we'll never be able to find chaos. Today, let's at least find some procedural formalities in this order. So we take it therefore that these are the 6 categories of people.
there are two more categories.
There's one more category
Which category?
there are 2 new tally numbers we have filed yesterday.
Which category do you
This
belong?
category is not called for verification. We were the original whistleblowers. Because of our original 2 writ petitions, a batch of writ petitions, there was CBI inquiries and there was certain orders.
Therefore, you want the process to be cancelled, right?
No, what we are asking for is, if the second limb of the judgment of the Honorable Division Bench holds good before this bench, that is to segregate, with regard to the people
Tainted
who
and the
are otherwise
untainted.
legitimate and got the jobs, and people who are not legitimate but still got the job.
Now, did you get the job or did you not get the job?
Then we will come into the consideration, zone of consideration.
Oh, you will be the beneficiaries of segregation.
Yes, precisely.
There is another.
Only rest are offshoot.
That's right. These 6 are the broad categories. Look, we are not going to shut out anybody who says in the hearing that, look, please give us 2 minutes. We'll also hear those categories. But broadly, these are the 6 categories. Now, 1 second. Now, we are not going to add to the categories anymore. We're not adding to the categories anymore. Now, tell us, Asa Sharma will be the nodal counsel for the state of West Bengal. We'll also, for the state and the staffs and the school
State
selection.
commission and those other private whose examinations have been cancelled.
They all sail in the same boat.
Same boat.
So on behalf of the private parties, is there any other nodal counsel whom we can appoint?
May I say one thing? When you're pointing out the category, please keep it there, because within that category of people who have been today dislodged, there are subcategories.
Obviously.
You have the OMR sheets, you have
That's all right. But if we start listing, Ms. Arora, if we start listing out all that today, we will be finding out now it will be like an argument today. We just want to give some procedural direction so that we will have one paper book common for everybody in this case. Otherwise, it will be impossible to sift through, 500 petitions.
It will become extremely difficult for my lords to put all the categories into one.
No, we are not. We are just appointing counsel so that at least the relevant rules and regulations, precedents on which people want to rely upon, all that is at least compiled and put before us. The lead writ petition is put.
All that.
have already filed, my lord.
But that's a matter of argument.
Because the
That-
prior to the whole lot. It's all, we.
That's a
can
matter of argument.
Where?
Ms. Arora, if we don't do this exercise, it will be impossible to write a judgment, which we have 1,000 petitions or 500 petitions, and you have odd petitions, counsel telling us, well, this page in this petition, it's impossible to actually get down
I
to
understand that.
type a judgment. So we have to have some chaos in this, some order in the chaos, rather.
But there is the chaos, absolutely.
Let the school service commission do
May
it.
I just
All right.
Shalini Kaul. Shalini
They are the
Kaul.
central.
Sorry, who, where?
Note, Shalini Kaul.
All right. So we've got Asta Sharma,
Let's come in.
Shalini Kaul, and who else? All right.
For the in-service candidate.
In service.
In-service, my lord, who were working from 2007.
Asta Sharma and Shalini Kaul will be covering your perspectives as nodal counsel.
CHATTERJEE would be.
No, I didn't get your lordship.
We are just appointing nodal counsel as in the CB matters to prepare one consolidated finale.
We are looking for in-service candidates,
In-service.
separate category altogether.
Everybody is in service.
2007, my lord.
Can I submit one thing?
You see, in-service candidates are exactly like Mr. Vaidyanathan, Mr. Raju Ramchandran, Mr. Patwalia, and Mr. Ranjit Kumar, whose appointments will be cancelled as a result of the judgment.
Can I just suggest, apart from these 6 categories, there are also 2 broad parallel categories in terms of the arguments. One will be 65B and the technical aspects, and the other would be the remaining. So these could be clubbed up together.
These are arguments. These are not categories.
Millets,
These are
because they'll
arguments.
help this court. Ultimately,
You
it
are
will
saying
help.
that the 65B certificate is invalid. So that's an argument. That's an argument.
Lordship,
All right. And
Lordship,
on this
similar-
side, one
similar-
second, please. Please don't talk out. 1 second. Don't talk out of turn.
Lordship,
Now,
similar matter.
don't talk out of turn. What applies to the left applies to the right as well. And to the center. Now tell us. Now I'll tell you what. Tell us now, on this side, is there any nodal counsel who would like to work with these two counsel we have nominated?
Mr. Rohit, because Shekhar Kumar would be there.
All right.
May I make one suggestion?
Mr. Shekhar Kumar? Right. All right.
Selected and.
Now, 1 second. In order to, no counter affidavit has been filed till date. Full stop. In the event that any of the respondents seek to file their counters, they shall do so on or before do saptah ka time de dijiye. If no counter is filed, the right to file a counter affidavit shall stand closed and the proceedings shall be conducted on the basis of the record as it stands. Next. Broadly speaking, it has emerged from the submissions of counsel on both sides that there are six that the categories in relation to the present batch of cases would comprise of the following. Bracket 1, the state government, the government of West Bengal, semicolon, bracket 2, the West Bengal Central School Service Commission, bracket 3, original petitioners before the High Court who are not selected, into brackets, representing classes 9 and 10, semicolon, 11 and 12, and groups C and D, bracket, and similarly situated persons. Bracket 4, persons whose appointments have been cancelled by the judgment of the High Court. 5, persons who would be appointed in pursuance of the decision of the in pursuance of the division bench, but where no action has been taken. Persons who would stand to persons who would stand to be appointed.
Persons will lose their job because of malpractice.
There is no direction. There is no category. There is no such directions.
Once, everything, right. Then that fifth category, then the fifth category we need not mention. And fifth, 5, the central, 1 second. We are not putting the fifth category. 5, the Central Bureau of Investigation. Full stop. We have clarified during the course of the hearing to assuage the concerns of all the learned counsel that these are broad categories and will not exclude the possibility of any person having a distinct case presenting it before this court. Can you please allow me to argue, dictate the matter? Full stop. To facilitate, full stop. Given the large number of petitions which have been filed before this court, it would be necessary to have a common compilation which can be relied upon by all the learned counsel at the time of the hearing. Full stop. To facilitate this, uske pehle likh lijiye. During the course of the hearing, we have noticed that the court has been apprised of the fact that Mr. Rakesh Dwivedi, learned senior counsel, appears on behalf with Ms. Asa Sharma, appears on behalf of the state of West Bengal, while Mr. Jaideep Gupta, learned senior counsel, appears for the school service, West Bengal Central School Service Commission.
Mr. Kaul also appears.
Mr. Kaul, you are appearing for
the state of West Bengal.
Okay. Yes, you can. The persons whose appointments would stand to be cancelled as a result of the impugned judgment of the division bench of the High Court are represented inter alia by Mr. C.S. Vaidyanathan, Mr. Raju Ramchandran, Mr. P.S. Patwalia, Ms. V. Mohana, Mr. Ranjit Kumar,
I will accept.
Ms. Meenakshi Arora, and Ms. Padmanabhan.
I am representing.
All right, so आपका भी नाम लिखो, Mr. Gidayat.
We are all representing, our SLPs.
Must be your lordship.
You are away from Parliament today.
No, our Parliament is not there.
And Mr. Roy is for whom?
For the similarly circumstance. Group D.
My lord,
Alphabetical order.
Lordship, I want to assist.
My lord, Mr.
Ranjit Kumar bhi dal.
My lord, Mr. Pratik sir.
Madhi Diwan also.
Lordship,
Fair enough, Mr. Ranjit Kumar, Ms. Madhi Diwan.
Mr. Pratik sir, my lord.
We are just putting out some names so that we know when the matter opens up who is appearing for whom.
Lordship,
Lordship may not put any name, my lord.
All right,
Don't
kiसी
put
का
any
नाम मत
name.
लिखो. All right, don't put any names because
Otherwise there will be a chaos.
all right.
Lordship,
ऐसा लिखते हैं हम, council appearing, all the council appearing in this batch of matters who fall into one of the above stated categories shall furnish details to Ms. Asta Sharma during the course of the day, so that a consolidated master list of council can be prepared. All right. Then we will say in order to facilitate the preparation of a common compilation, we appoint the following, by consent, we appoint the following advocates as nodal counsel, : 1, Ms. Asta Sharma, 2, Ms. Shalini Kaul, and 3.
Chatterjee is there in all the matters.
Kunal Chatterjee is most important. He's for the board as well as for the
Kunal Chatterjee.
It's very
3, Mr. Kunal Chatterjee.
because we are been approved.
Yes.
Report from day one.
Right.
At our instance, Mr. Partho.
Mr. Kindly.
Who?
Mr. Partho Steel, the advocate on record. Kindly.
Oh, Mr. Partho Steel. All right. The 4 nodal council, that Shekhar Kumar we already put there. The 4 nodal council shall ensure that they sit together and prepare a common compilation in the electronic form. Full stop. This shall be circulated to all the learned counsel appearing on behalf of the contesting parties in the proceedings. Full stop. This exercise shall be completed within a period of 2 weeks. The proceedings shall be listed for final hearing on Tuesday. Place it exactly after 3 weeks. 2 weeks to file the counter. If no counter comes, and we're giving 2 weeks to prepare it.
Lordship,
Right.
Lordship, item number 26.
Right. The council falling in the above categories will be at liberty to file their written submissions, not exceeding 5 pages each. Not exceeding 5 pages each. Stop. We would request all council appearing for a given category to prepare one set of submissions. Right? So that, Mr. Batwalia, Mr. Ramchandra and Mohana, please sit down together and prepare one compilation. Your 5 can become 7, but, we'll then have some idea.
But, Lordship, my lord, for the writ petitioners before the High Court, they have to deal with all these arguments. Their argument cannot be
One compilation means
one submission, one set of submissions.
One type of sum, but
I think Mr. Gupta, Mr. Dwivedi, and I'm standing
My
well.
submission is just limited to 1 point.
So,
Rest all is Mr.
fair enough, but prepare one set of submissions because you are the people who are challenging the judgment of the High Court.
Yes, madam.
They are the private parties challenging. The petitioners before the High Court are seeking to sustain the judgment of the High Court.
Yes,
We get the broad categories now.
One risk.
And state and SSC, etc. is concerned, your lordships, because notice has not been issued in our SLB. Let them just circulate. We can apply to the registry and get their stand.
All right.
That is.
There are new matters today. New matters in this, kindly issue notice and direct.
All the matters.
Notice shall issue in all cases where notice has not been issued thus far. However, it is clarified that one counter affidavit alone will be filed in the lead matter. Full stop. Now, one more thing which I wanted to ask you was that we'll have only one counter affidavit. That's one thing is very clear. Now, apart from that, so far as the state of West Bengal, there are basically the most significant challenges are by the private parties who are going to be ousted. but more important, the state of West Bengal and the School Service Commission. Now, I would like to have, just so that we have some idea about the facts, can somebody take the burden of preparing a dispassionate set of list of dates containing everything?
That will
So, Divedi, will you be able to do that?
We'll prepare
Everything there. We don't be selective. We only request the state government can do that. Don't be selective in what you are disclosing. Put everything on the record, because then it's a matter of argument. But otherwise, we'll not have a comprehensive set of dates. So please do that for us, so that.
One race.
Yes, their presence is very much required. The board, West Bengal Board of Secondary Education presence is very much required, because there is an excess appointment. School Service Commission.
The commission is the
No, we'll allow the state of West Bengal to do it. We'll coordinate with Mr. Divedi and both of you.
My lord would be kind enough, in the meantime, direct the CBI to place its report before the court. Let us know what has happened, how far they have proceeded.
And the West Bengal
Board of Secondary Education.
Love to see.
One
That the board is very serious before the Supreme Court. And unfortunately, SSC, before this single judge, did not argue. Board did not argue. Board did not appear. Board did not argue. Nothing, no seriousness. We would love to see that they have become serious now.
Only one SLST is there, my lord. Certain SLPs are not appearing in your.
All right, now we'll get on with our. I think we brought some order to what we are going to do.
I missed it, but did this honorable court direct the CBI to file its report?
We'll be on board now. These are representative proceedings. I mean, it may at the end happen that some SLPs were not listed or whatever. They'll follow whatever you. We have so many counsel across the spectrum making arguments. Everybody.
I have one respectful sub.
All right, now.
One respect.
All good things have to come to an end. All good things have to come to an end.
I have one request.
CBI report may be.
In this regard.
Already CBI has filed a charge sheet in this regard in all the four matters. RC 1, 2, 3, 4.
My lord, another thing is that, my lord,
CBI has already filed.
I can't hear you at all. And we'll not be able to hear anybody because everybody is talking out of turn. Now, though I don't use a hearing aid, we have switched off our ears to everybody in this matter. Hear it on the next.
CBI has already filed a charge sheet in regard. Let the report be filed on the next day.
Item 14. Item 28.
Lordship, item number 26 is related to same matter.
All
Item number
connected matters
26 is related to same matter.
All connected matters are governed by the same order. All connected matters are governed by the same order. We are not going to hear anybody else now today because this is only a procedural direction. Please rest assured that when we open the matter, we'll be hearing diverse viewpoints.
CBI report is very important.
Four charge sheet is
Four charge
important.
sheet has been filed.
Kindly
Four
consider.
charge sheet has been filed. Let that be clear.
Hold your horses for the next hearing. Yes.
Otherwise, the adjudication is
14,
impossible, my lord.
1 week rejoinder.
Charge sheet has already been filed by the CBI.
1 week time for
Detailed
rejoinder.
investigation.
They are afraid of CBI.
File it here and it's
Charge sheet, my lord. That is very important.
Let the direction be passed.
No, you are the villain of the piece. You are not allowing the board to progress. Now, please come on the next time, please.
Highly obliged.
Item 14, please.
Highly obliged.
We've already passed procedural directions.
Item 14, Lords.
Yes.
I appeal this.
Just 14.
It's coming after notice or it's before notice?
This after notice, they were present yesterday, Lords.
All right. So what do we appoint some, we appoint an arbitration.
Am I audible?
Online.
Your Lordship, am I audible?
Yes, Miss.
Your Lordship, there are issues pertaining to limitation in the matter, and that is why we are objecting appointment for this very reason. I am seeking a small accommodation if it can be listed next week because there is some new information which has come.
Please, my lord.
So what we'll do is, whether the claim is barred by limitation, let it be decided by the arbitrator.
Yes, my lord, I don't have an issue.
Your Lordship, there is a recent judgment, in fact, that your Lordships can decide the issue of limitation right now so that stale claims do not have to be
Launch
live.
into an evidentiary inquiry. We'll keep that issue open.
Your Lordship, on a bare perusal of the documents that they filed on record, it reveals that it is out of limitation. Plus, there are quite a few documents that they did not file. We filed in our counter affidavit. Your Lordship, I'm only requesting accommodation by a week because I'm being led by a learned senior who's not there.
That the claim is ex facial
Yes,
barred by
my lord.
limitation.
My lord, as regards the first matter, my lord, which is regarding the salary aspect, my lord, in 15, my lords, we had discussed with them. They said you give us more documents. Then we kept on wanting to meet them. They didn't meet. Then within 17 minutes, within 3 years of that, they never said that we are not going to give your salary, my lords. This is about salary. And then in 17, we in fact wrote to them. Then they didn't respond. Then we went to the Honorable High Court, where the Honorable High Court ultimately said it's an international commercial arbitration. You file it. So that aspect, my lords, in any ways, arbitrator can consider it, my lords.
Your Lordship. Lordship, in my counter affidavit.
For unpaid salary, the first case is claim for unpaid salary, right?
Yes, correct.
For the period April 12 to October 12.
Yes.
When did you issue a notice invoking arbitration?
Not notice invoking arbitration.
23rd Jan 2017.
There was correspondence before that.
When did you issue a notice invoking
17 minutes.
2017.
Correspondence. There was correspondence before that.
Correspondence is the can't doesn't save limitation.
They don't deny that we are not going to pay you, my lords. Lordship may just see that, my lords. What happens is
1 second.
5th November to
They don't deny it. So can you then therefore say I kept on corresponding and therefore my limitation is saved?
Lords, the first legal notice goes in 2015, not invoking arbitration, but Lordship may just see at page 86.
So even and when it's 15, and when did you invoke your arbitration?
But 17, my lords, first.
17 January.
All right.
First notice is of 13, 2013, 5th November,
yes,
2013, page 84, yes, annexure P2.
Yes, my lord,
that's
the
how
email.
you started.
No, not
now.
And your last is 2017.
Yes,
and your arbitration petitions filed in 2019.
So, my lords, what they say at page...
Now, second is transfer of shares by R2 to P.
Yes, my lord.
And R2. Now, petitioner and R2 were allotted certain shares in R1.
Yes,
R2 by a letter dated September 11 stated that R2 held 2 lakh shares in R1 which belonged to P.
Yes,
and there is a failure to transfer the shares.
Yes,
now tell us when is the notice invoking arbitration?
No, that's because in the other two matters I understand because there, only the first aspect, may I just make an endeavor to convince your lordship on the first matter, because that is the major chunk of the salary which I should have got. Lordship may just see page 88 now. Page 88 of my milords. In 13 I write to them. They never say we are not going to give you, because ultimately what happens is if they don't give. Yes, ma'am.
Say that we are closing argument now.
Yes, ma'am.
You by Friday 5 p.m. you file a short.
Yeah.
You file a short note by Friday on limitation, on how your claim is on limit. If it's within limitation,
just one for my satisfaction.
Just file it.
See that
and Ms. Jasmine, you also file your response by Friday 5 p.m. We'll close it for orders and then decide it. Unless it is
Friday for hearing. Your Lordship, if it may be kept on Friday for hearing, because I do not have instructions to argue the matter today.
Then you don't argue. We'll hear him and pass an order. You can't hold the court to ransom like this all.
May I just point out a few points in that case?
That's what we are trying to tell you, but you are trying to thwart the court from asking you to file a counter, not a counter, a short submission that it is barred by limitation. Give it to us by Friday. Prima facie, you are right that it appears to be barred by limitation. We are allowing you to file a short note and tell us how it is barred by limitation. He says,
we will do the needful, Your Lordship.
so you file your submission
One
by
differentiation just for assistance of your Lordship. Because in those two matters, there's one agreement, which is the common agreement.
Right.
Because in that, there's a tribunal of three, which was the thing. Which is mentioned in the clause. This is a sole arbitration. Milords. And Milords is a different agreement. Now, service agreement, salary is fixed, Milords, in that. Because I'm only saying, Milords, if not that matter, Milords, the facts in this are a little better off than that, because the limitation. That's the which I will try to assist your Lordship in the written submission.
But in this matter,
yes,
when did they acknowledge that a claim is due to you, or that they have acknowledged the jural relationship?
Lordship, just see page 88. The wordings are important. They say you give us more documents so that to convince us that more salary is due. That's in 15, within 3 years, my lords. Within 3 years. Page 88, my lords. They say, I also request your office.
Denied.
No, he denies generally like that. But Lordship, just see, I request your office to provide list of documents based on which your alleged client are demanding said claim, and then direct your alleged client to provide inspection of said documents by providing certified copies to me along with this full address.
So which annexure?
P5 in the first one.
The first, okay. Just read it now.
Yes, please. But this is with reference to above referred legal notice, as well as legal warning forwarded from your office to me, and I have gone through and found that your office has not provided vital particulars of the claim, with circumstances under which said claim is due and payable to your client. I also request from your office to provide list of documents based on which your alleged clients are demanding said claim, and then direct your alleged clients to provide inspection of the documents by providing certified copies to me along with this full address where said documents have been kept, so that I can verify the genuineness of the claim and if it is payable. I can pay for the same. However, if there is any difference or clarification required, then I will clarify the same to amicably settle said claim as alleged. So this is in 15 they say. Then he says I deny the amount.
So according to you, what does this letter indicate?
He has never foreclosed or said, then I am not going to pay you. If you satisfy me, I'll pay you. Then I try to meet him. We would never meet. That's what is mentioned by legal notice, which is within 3 years.
What is the date of the legal notice?
Because that is at page 89, 23/1/2017. And this is of 10/8/2015.
And
there I have said, Milords, that we had.
Then you filed the petition within 2 years.
Yes, then we filed it before the Honorable High Court. That was within 3 years' time.
That's right. High Court says it's an international commercial
Then
arbitration.
19 immediately they say it's international commercial. I come before Lordship, it's pending since.
Now, Ms. Damkipalu, what do you have to say to this? This is his argument. He says that, look, by your letter at page 88, you didn't deny the existence of the jural relationship, one. And two, you said that, look, please send me documents. I'll verify the claim and then decide whether anything is due and payable. We can amicably settle the matter.
Your Lordship, first at page 88 itself, I have denied the claim. But in my counter affidavit at page 19, there are some documents that they have not filed. They have suppressed these documents. In my document, I've clearly said that he owes me money, in fact, and that document I've put in on record as R1.
Counterclaim. That's really a counterclaim.
Your Lordship, in fact, it is like a set-off because, in fact, he owes us money, and in 2000.
Then that clearly then that has to be arbitrable. You can always raise it before the arbitrator by way of a counterclaim or a set-off.
Your Lordship, but as far back as in 2017, I had even appointed a nominee arbitrator. They did not even respond to it. It is R4 in my counterclaim. They could have responded. They did not, and then thereafter they choose to move the honorable courts at their convenience, their time, and their space. Today it's a stale claim. Lordship, there are, may I?
He gave you a notice on 6th of August 15, to which you respond on 10th of August 15, right? And you say that I will examine the genuineness of the claim. Then his notice invoking arbitration comes within 2 years, and thereafter, thereafter he files within 2 years. So it's not a case where we should really, in this case, reject it out of hand as barred by limitation. It's a matter which we'll keep open for the arbitrator to decide. So now tell us, is it a sole arbitrator? Is it a...
No sole in this matter, an advocate, because the amount will be around 2 crores, because as on today, if the value of the dollars are taken into consideration.
Right.
In this matter, in R4, an extra R4 in my counter affidavit, I've clearly said that at that point of time, I said I'm appointing an arbitrator. He kept quiet. He was not interested.
It was before.
Can he today now come to court at his time and space and say, now I want an appointment? Also, Your Lordship, there was a...
to take place?
Bombay.
Also, Your Lordship, he was bound by a 3-year contract. Lordship, also an arbitration petition, may I? In petition numbers 20 and 22, my learned friend says that his right arises from the fact that his shares were not given.
We'll appoint a sole arbitrator. We'll appoint Mr. Having regard to the nature of the claim, we'll appoint Mr. Mayur Khandeparkar.
Yes, I have the name in my mind also.
So we'll appoint.
I'm requesting that this issue be kindly permit me to file a note.
Keep the issue open. We expressly clarify that the issue of limitation, including all defenses and counterclaims, are kept open to be urged before the arbitrator.
Arbitration petition 20 and 22, it is there is no such letter there. So my learned friend can't be pressing that. That is as on date of his himself leaving employment. That is on 2013. So he could not be pressing that.
Matter of merits, but yes,
25.2 is barred by limitation.
Those two could be said to be. I don't want to accept that, but your lordships can take it. Because the correspondence happened in 2017 directly.
25.2, no?
Yes, Milord. 1 and 2, Milord. 25, the first matter, which is arbitration petition 60.
That we are.
Yes. This is about 3-member tribunal. Milord, there in this only section 22 could be an answer. Milord, they had to only give me a share certificate, which was not given.
Yes.
Section 22 of the breach of contract continuous cause of action. That could be the only answer which I can have. Though there was correspondence and discussion.
On that, what you do is give us a short note. Ms. Damkewala, on 25.1 and 25.2, which seems to be barred by limitation, just give us a small note by Friday, 5 p.m. and we'll most probably will be rejecting it unless there's something radical that
I'll try to convince your lordship.
Your lordship, I'm just requesting that this matter also 16 also be kept open. I will give a note, your lordship, the judgment may come together because there will be no prejudice to my lordship.
There's a difference there.
25.1 and 2, written submissions to be filed by 5 p.m. on Friday and email to or arguments for judgment reserved. Yes.
Highly obliged.
Obliged.
सबके पास भेज दो। आगे वाला सबके पास।
My lord, I may be permitted to circulate the order, which may.
Council in 14, just 1 second. 14, Mr. Chima. 14, we have passed that order in the main matter. 14. We have referred to arbitration on 14.
Arbitration petition number 16 of 2020, 2019.
And the other two we have concluded.
20 and 22. That I'll submit.
Okay. So 14.1 and 14.2 is where you will be both filing your written submission. The court master read.
But that is a 3-member tribunal and different arbitration clause.
All right.
Same agree. Okay.
I may be allowed to circulate the order.
Yes.
Yesterday, my.
So it was very clear that Justice Sular
Yes,
was to be appointed as the second arbitrator.
Exactly.
There is a little ambiguity in the order which is impugned, but if we read both orders together, it appears that Justice Sular is appointed as the second arbitrator, which was the point you were making yesterday. Who is appearing for the other side?
It is coming up for admission, my lord.
So now what? Why are you challenging the order?
My lord, we would like a sole arbitrator to be appointed instead of 3.
But what does the arbitration clause say?
Arbitration clause says, my lord, if it with the consent of the parties, a sole arbitrator could be appointed.
But they are not consenting.
No, my lord. In fact, when the same was invoked, they had proposed one Mr. Grover.
You never accept. You accepted.
I
One second.
Yes,
you accepted Grover.
Yes, ma'am.
Then you appointed Justice Sabina.
Yes, my lord. Because
so you were not then agreeable to Justice Grover as the sole arbitrator.
No, my lord. We were agreeable.
But then why did you appoint Justice Sabina? Because that order which you gave us today,
yes,
which says this, it has been brought to the notice of this court that by communication dated 10/4/23, the respondent department had given consent for the appointment of Justice Grover, Mr. Grover, superintending engineer, to act as arbitrator as per the agreement.
Yes,
the same had also been consented to by the present petitioner on 13/4.
Yes,
however, having not entered into the arbitration for a period of 2 months, by communication dated 12 June 23, the petitioner company had chosen to nominate Justice Sabina, the then acting Chief Justice, as their nominee.
Because
so,
the state never participated. In fact, my lord, they never cooperated.
But now sole arbitrator, how much is the claim?
My lord, around 13 crores, my lord.
But now to have a sole arbitrator,
Lord,
we can't.
With the consent of the
but
state.
They are not consenting.
My lord, no, my lord.
Or you didn't consent also.
No, my lord, actually we did. My lord, in fact, my lord, even in this petition, they have not entered appearance. I take my lordship to paragraph 3. Respondents were put on notice in the said communication dated so and so, which led to the filing. The respondents have not chosen to file any reply despite putting an appearance on so and so date. Their inaction led to
Record now stands. It will be Justice Sabina and Justice Sular, right?
yes, my lord, and both of them have appointed the third arbitrator also.
They have already appointed a third arbitrator.
Yes, but arbitration is yet to commence.
That's all.
Even the statement of claim is yet to be filed.
Dismiss it then. No.
But if I may, if I may.
Now we've heard you a lot since yesterday. Now I think we'll
My
just.
lord, if I
Chalo,
just,
item 16.
my lord, one.
No, sorry, we have dismissed.
My lord, if the state could be put on notice, my lord,
I
our
don't do
communication with
anything
them-
like that. Now the arbitrators have already constituted the tribunal.
My lord, my communication with them privately is that they are amenable or agreeable to a single sole arbitrator.
Private communication, you know how the state is, yes.
My lord, exorbitant cost both for the petitioner as well as the exchequer.
This is the case which I had opened yesterday. I'll just refresh your lordships on some of the facts over here. Now, here what had happened was that as I am appearing, Manoj, your lordships will see for the members of the Bharani family and who are the SLP petitioners. Now, there was another family called the Harwanis, and both the Bharani family and the Harwani families were together in the real estate business, and they had two firms. One firm was Dreams Infra Vision and the other was Dreams Infrastructure. Thereafter, certain disputes and differences arose. So they entered into what is known as a memorandum of understanding or a settlement agreement as described in the suit. And that settlement agreement is dated 19th November 2020. The 19th November 2020 settlement envisaged that all disputes and differences now come to an end, including with respect to those firms. Moving forward, as far as the Harwani family is concerned, they are to retire immediately or in one of the...
Just one second.
Yeah. So there were these firms, there were disputes and differences, and there is an MOU entered into between the parties on 19th of November 2020 to put an end to all these disputes, etc., which were there, and it charts out the way forward. The way forward essentially is that the respondents, who are the Harwanis, are to either immediately exit in respect of one firm or are to exit in the future. There is a whole bunch of steps envisaged in regarding the transfer of properties, etc., and parties are to move forward. The Bharwanis remain as continuing partners as far as the firm is concerned. This is broadly where it was. Now, it was our case that after taking certain steps, etc., there was a default on their part. So we filed a suit for specific relief. That is the suit where two applications were moved under Section 8, saying that there is an arbitration agreement between the parties and refer the matters to arbitration.
Your suit is for specific performance of the retirement.
Primarily, it is of the MOU.
MOU and the retirement cum reconstitution.
That's right, of 19th November 2020. And I might add there are also prayers for certain damages, etc., but that's secondary. But primary.
And your suit is the settlement is basically a settlement by which the Harwanis go out.
They go out.
And
the Harwanis go out.
You're Bharwani.
Yes, I'm Bharwani. The respondents go out, and then there are all sorts of adjustments, etc., which are to be done.
Now, in that suit, they file a Section 8 application.
Yeah, two Section 8 applications are filed. So let me just tell you, there are lots of interlocutory applications saying that 711, etc., etc. Those are all over. We are concerned with the Section 8.
Trial court dismissed their Section 8.
Section 8 dismissed.
High Court is now allowed.
Now High Court is allowed. Now I might just mention 2-3 facts.
What is the point that you are making?
Yes, so I'll just state my points. My first point is that they invoked 3 arbitration clauses. All right. Their prayer is that there are 3 arbitration clauses. Please make a reference under one of the 3. One is under the MOU. The other is in terms of, I'll take you to all those 3 clauses. My respectful submission is
MOU. Then
yes. Then there is a deed, a partnership deed of 1st April 2017. May I give you the 3 dates?
Yes, please.
The MOU is dated 19th November 2020. Where they invoke under clause 19.
Right.
There is a partnership deed, the erstwhile partnership deed of 1st April 2017, where they again invoke under clause 19 of that partnership deed.
Right.
And the third document is there's a deed of retirement and reconstitution that is dated 19th November 2020. And according to them, they invoke under clause 27 of that third document.
Okay. So they, according to them, the original partnership deed, the MOU, as well as the retirement cum reconstitution deed, each of them has an arbitration clause.
According to them, each one of them. I might just add, as far as the High Court is concerned, it has not gone on the first clause in terms of clause 19, but I'm going to take you to that agreement under the MOU. But the court was satisfied as far as the partnership deed and the reconstitution deed is concerned, and therefore says go to arbitration. Now this is the background. Now,
Mr. Diwan,
correct. Now let me take you to those clauses.
Diwan,
Sorry.
Mr. Diwan,
Yes.
your suit is for specific performance of
Yes.
the MOU.
Yes.
If the MOU has clause 19,
Yes.
which contains a reference to arbitration.
Yes. Then I may be in trouble.
See what clause 19 really is.
So first, let's see that. I agree with you. So yes. So now, Manoj, may I take you? I will go directly to that clause if you like, but I want the permission also to just take a couple of recitals of that particular agreement. So just have a look at the MOU. You will find it at PDF 148. Now, I hope my PDF is right. It's annexure P4, page 117.
Let us see that 1 second. The arbitration.
Do you have page 117 or Manoj, PDF 148? Annexure P4.
PDF is incorrect again.
Annexure P4, right?
Do I have the same pages?
It will be 140.
140, 140.
PDF will be 140.
All right, so your lordships have that. It's P4.
That's P4,
Yeah.
correct.
Yes, we got it.
I'll just make a reference to the. I'll make a reference to the handwritten number. So your lordships have that, correct? So one part is the Bharanis, and the other part, or the second part, your lordship will note is the Harwanis, correct? This is the memorandum of which I am seeking specific relief. Now please see on page 118, there's a recital. It refers to one of the firms, Dreams Infrastructure, and then 119, it refers to the second firm, in Dreams Infravision, correct? So it makes a note of these two partnership firms.
Clause.
I don't think so.
It merely says they will get, then party number 1 and party number 2 shall get cleared such misunderstanding or conflict of opinion.
Right.
In consultation with Shri Vithaldas Mohta,
right,
resident of Amravati.
Yeah. So
it's not an arbitration.
I don't think this is an arbitration clause, and I must say, in fairness to the High Court, they haven't gone on this. Though this is one of the clauses which is invoked. But what I wanted to point out in the earlier portions, which you may just note.
Now, High Court goes on the partnership deed and the
Yes, but this agreement, just have a look at, my lords, just please go to page 123. Just see the recital, my lords. The whole partnerships are over. We are now untangling from this earlier relationship. We are entering into a new relationship. So please see this final recital at page 123. I'm just reading it. And whereas in view of the aforesaid pact, the parties of the first and second part have negotiated with each other for settling the terms and conditions, subject to which the disputes between them are agreed to be resolved in the near future. And after negotiations of the parties, the first and second part have agreed and settled and concluded between them the terms and conditions on which all the disputes are agreed to be resolved and have decided to execute this memorandum of understanding so that the future course of action is to be taken by both the parties in accordance with this MOU.
This now replaces all other.
It completely supersedes. Now please have a look at so then they say that the partnership is to be, obviously to be liquidated, etc. And there is one very important clause, clause 14 at page 133. This will have a bearing on the other arbitration. Please see clause 14 on page 133, part of the MOU. The party number 2, which is the Harwanis, shall retire from the partnership firm Dreams after its ongoing project, Dreams Pride, shall be completed on or before 31st December 22. Now this is, I'm going to come to that. This is what is now invoked. So express requirement of that they are going to retire, and then, my lords, it goes on. So now clause 19, your lordship has seen. So now this is, now please go to the partnership deed. of 1st April 2017, which you will find at Annexure P2, page 89. So this is a much earlier document, 1st April 2017. This is where they are to exit from. Your Lordships has partnership deed?
Yes.
Now, please have a look at clause, yes. So, but this is for Dreams Infravision. And now please see the clause, clause 19. This clause you will find at page 96. If any, may I read it? If any dispute or difference shall arise between the parties hereto touching the business of the firm or interpretation of any of the provisions hereof or otherwise, however, relating to the firm and its business, the same shall be referred to arbitration of a common arbitrator. Now, my respectful submission is, number one, this is now superseded by a subsequent memorandum of understanding by which does not contain an arbitration clause. One. Number two, it contemplates express. So where is the, and number three, this is confined only, this is now very important, my lords. This is only for infravision, this arbitration clause. It is not for the other firm. It is not for the specific relief aspects which I am seeking. This is, my disputes now are not confined only to this firm. They are on a much larger canvas. And therefore, this restricted arbitration clause, which may have been at one point, as far as the firm disputes are concerned, wide enough, has no application to the present MOU with regard to which I am seeking specific performance. Too narrow for that purpose, assuming that it is not superseded. Too narrow for my purposes. Now we come to the third. I'm sorry.
Yeah. At some stage, we'll only to you that
yeah.
You filed a suit for specific performance,
yeah.
right? You are a plaintiff. Would it not be also in your client's interest that everything is resolved by arbitration?
So I'll come to that as my final argument. I'll come as an alternative plea. I'm going to come to that. But Manoj, please, at this stage, this clause, I can't go under a firm.
Mr. Diwan, we'll hear you dispassionately on your arguments and merits, but at the end, we'll ask you this.
Yeah, so I'll answer that, Manoj. So let me just complete an answer.
What if we appoint?
Yes, so first, okay, so then...
A person, you know, of...
All right, so Manoj, first and foremost, I've taken instructions on that. So let me ask you, without prejudice to rights and contentions, I've got 3 requests. The first request is, if your lordship is to appoint, and this is to be treated as an arbitration agreement, if they consent to that, and my suits do stand transferred to that sole arbitrator, I will accept that. Point 1. So, however, sorry, but I have 2 other issues.
Just 1 second, so that to have clarity, we appoint a sole arbitrator.
Yes, yes.
Right? And the arbitration
by an agreement here recorded in this court, not by these clauses.
No. Now we will, this will be an arbitration agreement, our order.
Correct. And the suit stands transferred to that arbitrator.
All the disputes and differences which are raised in your suit.
Yes.
Will stand transferred to the arbitrator.
So 2 more requests. 2 more requests. My first request is, I don't want a situation where they start now reopening and counterclaiming because there is none. My suit, because this is the whole right over there has been closed. They have filed their written statements, etc. I don't have a problem with that. But I don't want a new impetus given by an arbitration over here by saying, oh, now fresh timelines apply and X will counterclaim, etc. That's one concern. The second concern is that they're stripping assets from this firm, from the firms. So therefore, I've asked for an interlocutory order. I am requesting a time-bound interlocutory order may be passed, and then we can go to the arbitrator.
What we will do is this, that we will ask, once we appoint the arbitrator,
yeah,
we will say that you can move the arbitrator under section 17.
Yeah.
And the arbitrator may consider any request for emergency, emergency measures.
No, but there has been, there was a status quo order, and then they have started stripping it. So therefore, I have asked for an interlocutory relief here. I have asked your lordships, please see at page 64. I have asked for a maintenance of status quo and not to create third-party rights and third-party interests. You may make it time-bound for 8 weeks or 6 weeks or whatever you consider appropriate.
There is a problem in that way.
After this order,
just one thing, we can suggest one thing to you, in fairness, so that we don't have to, it will help us also. Until the section 17 application is decided by the arbitrator, we'll ask the arbitrator to take up the 17 application immediately. You may make a statement that without prejudice to your rights and contentions, that for a period of, say, 6 weeks, 4 weeks, 6 weeks or 8 weeks, you will not dispose of the assets and without
What my
prejudice.
statement like this, no?
There's
That would be very fair.
Make a statement. That's very fair. That's very fair.
Give this impression.
That's
Please
very
appoint
fair.
anyone that you feel.
Now, the this is from Nagpur or where is it from?
Amravati, properties are Amravati, so
Amravati.
anyone that they want or your lordships wants.
Mr.
But
Diwan, why don't
this
you both come
ended.
together, and if there is some arbitrator in Nagpur, a former judge of the High Court, you can tell us.
I've got 3 names here, your lordship may choose
Why
one.
don't you just give the 3 names to your learned
I have
strangers?
Justice Daga, Justice BP Dharmadikari, Justice VM Deshpande. I mean, I just asked for 3 names.
Any one of them, your lordships may appoint. Any one of them.
Whatever your lordship. So, Nagpur, right?
Like, all 3 based in Nagpur.
Yeah. Whoever.
Daga,
Anybody. Will you proceed forward from the district?
BP is not related to the council Dharmadikari who appeared, no? In this matter?
Dharmadikari.
Subodh, he's not related to Subodh, no?
But surname is same. I know.
I also.
Now, your lordship, may I just request you to go to page 64? I just, the only point is that's my interlocutory prayer, which is because the partnership firm properties were one. The MOU extends it to other properties because the MOU. So my prayer for interim relief was not to change the nature, title and ownership of properties described in the MOU. So his statement must cover everything which is described in the
nature, title and ownership of the properties.
Yeah, described in the MOU. That's all. Correct. And well, finally, the matter proceeds from the stage of the
That does not mean that I don't have a right to file counterclaim.
But where's the question if it is closed here?
No, but Mr. Diwan, suppose in your suit today, he files a counterclaim.
It's a suit of 21.
Yes, December 21.
No, 1 second. You would be entitled to plead that his counterclaim is barred by limitation. Then,
how are you
so if you can file a counterclaim in your suit, subject of course to all your defenses that is barred by limitation, you will say all disputes between the parties arising out of there's any the petitioner has instituted a suit for specific performance of a deed of settlement. Suit is for specific performance only of the MOU or also of the retirement come reconstitution. What is the prayer?
It's for the MOU.
Right?
Terms of the MOU.
There's a problem. Just see prayer clause Roman 3. And with it covers, they say that they have suffered a loss of 30 crores in all 3 projects. Means all
the petitioner, we'll just say,
covered by the
what is the number of the suit? Tell us, and where is being
93 of
a regular civil suit?
Yes.
Special, not valuation.
Special civil suit.
393 of 2000 pending before the joint civil judge.
Senior Division Amravati.
Civil judge, senior division Amravati. Regular special civil suit 393 of 2021 has been instituted by the petitioners before the joint civil judge, senior division Amravati. Full stop. The trial court rejected an application for a reference of for a reference to arbitration in terms of Section 8 of the Arbitration and Conciliation Act 1996. Full stop. The High Court of the Nagpur bench is a single judge at the Nagpur bench of the High Court of Judicature at Bombay, by judgment dated 30 May 2024, reversed the judgment of the trial judge and ordered a reference in terms of the provisions of Section 8. Full stop. The matter has since traveled to this court. Next. During the course of the hearing, it has been agreed by learned counsel appearing on behalf of the contesting parties that all the disputes and differences between the parties arising out of special civil suit 393 of 2021 be referred to the sole arbitration, be referred to arbitration, and that Chief Justice V.P. Dharmadhikari, former Chief Justice of the High Court of Judicature at Bombay, be appointed as sole arbitrator under the Arbitration and Conciliation Act 1996. Full stop. It is clarified that the arbitrator would be at liberty to decide to adjudicate upon the claims and the suits claims in the suit, as well as the counterclaims, if any. Full stop. However, all the rights and contentions of the parties on all aspects, including on the issue of limitation, are kept open. Full stop. The arbitrator would be at liberty to fix his fees in consultation with the parties. In view of the above agreement, the specially petition shall stand.
Agreement entered in, recorded in this court.
In view of the agreement as recorded above during the course of the hearing before this court, the specially petition shall stand this court.
My learned friend's statement.
Yes. उसके ऊपर लिख लीजिए. On behalf of you are for all the respondents?
Because I am for 1 to 4, but this is contesting.
On behalf of the respondents, it has been stated
in both
that
matters.
That for a period of that until 8 weeks, 15th August, 14th August, that until 14 August 2024, the respondents shall not alter the status quo in regard to the ownership, title, and
nature of the properties described in the MOU dated 19/11/2020.
Properties described in the MOU.
The status quo as of today, we will maintain till 14.
Status quo as of date in respect of the properties described in the schedule to the MOU dated 19th November
2020.
2022. 2020.
Described in the MOU.
Described in the
not necessarily in the
described in the MOU. And the above statement has been made without prejudice to the rights and contentions of the respondents. Full stop. The petitioners would be at liberty to move the arbitrator for interim reliefs in terms of Section 17 of the Arbitration and Conciliation Act 1996.
Very good.
Yes, both matters. 16.
Yes, both matters.
Both matters. Thank you. Very fair of you. Thank you.
Any items? Suit is of December, we're going to finish by arbitration point at an award. Anyway. Now we have issued the matter.
You only want to do it for
Chief Minister against another. This is a case of complete political vendetta. I have several questions to raise, my lord. The moment a new government comes, it starts against the earlier chief minister. Now, my lord, the most important point is a commission of inquiry is ordered under the Commission of Inquiry Act. It is elementary, my lord, it's a fact-finding body. It's not a judicial body.
Has no binding character as such.
It's not a judicial body. But, my lord, what is ordered is a judicial inquiry. Under the Commission of Inquiry Act, completely, my lord, without jurisdiction. My lord, only a court orders, my lord, a judicial inquiry. Kindly turn, my lord, to PDF 313. This is the first question.
Yes,
I will show to your lordship, my lord. Even, my lord, what is sought to be inquired is a matter which is pending in quasi-judicial tribunals. This is a case of complete overreach.
Which is the annexure?
My lord, it will be P16. PDF 313.
Let's see the.
Lordships have that?
Whereas.
No, my lord, see on the top. Energy, right from here, Department Commission and Inquiry under the Inquiry Act appointed Justice so-and-so, former Chief Justice, former so-and-so, to conduct a judicial inquiry. Number one. Then, my lord, it goes on, whereas. Now, your lordship turns to
PDF
316, my lord, paragraph 2. Now, therefore, in exercise of powers, paragraph 2, my lord. Again, my lord, in the middle, it refers to the name of the judge, so-and-so, to conduct a judicial inquiry. Not a connotation of a judicial inquiry is entirely different. So that's the first.
Right at the top, where is the judicial word?
Paragraph 2, my lord, at 316 PDF. 314.
Now, therefore, in exercise.
Item 2, middle, my lord, to conduct a judicial inquiry. That's the thrust of the inquiry.
But ultimately, they are the source of power is section 3 of the commission.
Which does not empower a judicial inquiry.
But therefore, we'll clarify that this is not a judicial inquiry in that sense.
No,
It's a commission of inquiry. We'll clarify that. By calling it a judicial inquiry. No, but they can't convert it into something outside the scope of the commission. It's confined. We'll clarify that.
No, but that's not the end.
Who's appearing for the state?
I am.
I have to show you several.
We'll record your state.
No, 1 minute.
Retired judge is sitting, sometimes you say judicial.
Just 1 minute.
It can't go beyond
this
section
is my
3.
only point. I have to show you several things.
Yes.
I started with this, Lord.
Yes.
That this is outside the ken of the act, number 1. Number 2, you cannot, fix responsibility in a fact-finding body. And 3, that it is in respect of matters, of purchase of energy by one state, from another state due to crisis. And that purchase of electricity is a subject matter currently pending, for approval of tariff before the commission. How can, there be an inquiry?
But that is for the approval of tariff, is it?
Yes.
Right.
But we take it that this is wide.
This state, the bifurcation happened in 2014.
Yes.
This state, was to get a particular share of, electricity on account of bifurcation. This state didn't get it. There was a power crisis. So the state said, we will purchase, from another state. So we purchased from state of Chhattisgarh. There was a PPA for purchase, which had to have approval of both the electricity commissions, that is, of Chhattisgarh and, of Telangana. So both, went for approval to the state commissions. Both were approved. The Chhattisgarh said that the tariff should be 3.90, which is the lowest. Against that also, we were dissatisfied, even though it was lowest in the market. We have filed an appeal. It should be lower. So there is, my lord, power purchase, my lord, is sanctified by the two ERCs. The question, my lord, of 3 points.
The only thing we just seem to raise, I mean, in the terms of reference at 3A1,
Yes.
without following the process of open competitive bidding.
But, my lord, with great respect.
287, all the 4 contracts, 287 on.
Please. My lord, with great respect.
Without any bidding.
They
That part about judicial, we'll have to clarify. That will clarify that this is a inquiry under the Commission.
I am saying so. Please say I am saying so. Lordship will
Lord,
I am
we
saying.
can't do it. Just turn to para 4 now. Just bear with me. Can there be a judicial overreach, my lord, by an inquiry by a retired judge sitting over an appellate tribunal whose appeal comes to your lordship?
But assuming, suppose, let's take it against, because you will have to take the facts as they may emerge totally against you for the sake of argument. Suppose Justice Narasimha Reddy comes to the conclusion that, well, you were responsible for.
I'm nothing against the judge.
No. The commission holds that you are guilty of some wrongdoing. That has no sanctity in law in the sense that they cannot enforce that against you. It's an inquiry. It's a non-binding commission of inquiry.
I am the former chief minister. He is the current chief minister. He has been making RTIs before he became chief minister on this question. I mean, you have to see a context. And, my lord, how can the court dismiss on day one without calling for a reply? These are not matters which can be, my lord, decided like this. I have also raised an issue of bias. Before, my lord, the matter could proceed, Mr. Reddy, my lord, makes a public announcement, my lord, in a press release that we have now come to this conclusion. We have come to this conclusion. I show you all that.
No, that we will look at. That we'll certainly look at.
Be a case of dismissal on day one by an order of 5 pages without calling for a reply, without talking about the fact that this is vendetta, that it is pending before the tribunal, that Mr. Reddy has addressed a press conference before coming to any conclusion. These are not matters, which, and clearly it's a case of vendetta. The moment a new government comes, you start against the chief minister. That's how it has happened. So it has several connotations. It has larger context. Kindly, turn to paragraph 4. Kindly, turn to. Let me see. Kindly, see. Start from paragraph 3. Let's see from 3 itself. But before I read the terms, would you lordship have a look at the act? You know, kindly turn straight to section 3. This is not so-called the charging section. Section 3. Not middle of the section. Appoint a commission of inquiry for purposes of making an inquiry into any definite matter of public importance and performance of such functions. So a definite matter of public importance. It is not, my lord, routine matters of executive power of the state in doing, my lord, day-to-day business. Matter of definite public importance. My lord, it happens when, my lord, people are killed in a mob. Things like that happen. It is not to decide, my lord, every day, every executive government, my lord, decides hundreds of things. To have power, to have an electric power station, etc., etc. There is no, my lord, issue that this can't become, my lord, a super, my lord, omnibus Lokpal sitting over, my lord, every decision of the state government. And it is obvious that this has happened only because of the term of election. My lord, this issue is of 2015. We are today in 2024. Definite, the words are very clear. Definite public importance, not, my lord, a contract executed in this form. Who has lost in this contract? There is this hue and cry that people have lost confidence, my lord, in a public contract. And I will show you that we bought it at the lowest from a state government. I can understand, my lord. I told some lackey, come on, you give me power. And there's nobody, no check. I bought it from a state government. I bought it at the lowest price. I am not happy with the price. Matter is pending. Both the ERCs have decided. Still matter is pending. From 2015 till today. Now to say, why didn't you have a power station? Why didn't you tender? The law is clear. In matters of urgency, in matters of subsidy, your lordships have said in the natural allocation case that everything cannot be by tender if you require power to do. 2014, the state is bifurcated. We have industry, we have farmers. There is a crisis, my lord, we are not. Even till today, my lord, in this spot, disputes between the two governments on allocation of assets, allocation of, my lord, public servant is still pending. I am still doing those cases. So where will the employees go? Where will power stations go? All this is pending.
All right, that's one aspect. That this is not a matter of public importance.
That's very important. Now, my lord, have a look at what is meant to be inquired. The lordship read paragraph 2, now turn to 3, the terms. In the year 2014, my lord, A1, in the year 14 to procure power without following process of open tender, but on nomination basis. My lord, he does on nomination. Directing DISCOMs to apply for corridor solely on the basis of anticipation, to make full payment to PGCIL with respect to corridors also. PGCIL is not a private body. To inquire into correctness and propriety of the decision taken. On the next page, to establish Badri thermal power with subcritical technology rather than more efficient super technology. Is this not a matter to be examined? If you have two choices, somebody takes one choice, somebody takes another choice. In hindsight, you say you did this. It's like saying, should you buy an electric car today? Should you buy hybrid? Or should you correctness of decision for establishing Yadari thermal power with coal supply of Singareni? Singareni is also not government. Singareni is also government. In awarding EPC contract without tender, in addition to terms of reference to fix responsibility for lapses. Now, my lord, with great respect, you see, my lord, 4, you fix responsibility. So if there is a report which is supposed to be fact-finding, fixing a responsibility, what else is left? Take the report and, my lord, go and file a case, and that's it. Now it goes further. This is how, my lord, this inquiry is done. Now I wanted to show you, my lord, if see the chart, my lord, where we purchase at the lowest price.
PDF 306.
307.
Running page 280. PDF 30.
Where is it? Kindly, my lord, turn to page. Running 281 PDF.
Annexure P14.
Annexure P14.
Read this.
This is, my lord, yes, I am going to show this. This is very important. Annexure P14, my lord. PDF 307, running, my lord, 280, Annexure P14. Now, this is, my lord, Telangana State Power Coordination Committee answering Milord under the RTI Act to state public officer. Your Lordship will find the subject, the applicant is the current Chief Minister. He is the applicant. He says what is the rates, etc., which you have Milord asked, purchase power. Kindly turn to 281. So the Telangana State Power Corporation, Milord, gives the answer. See, Milord, public sector, middle of the column, first column, public sector, Singareni and Chhattisgarh. Chhattisgarh power rate, Milord, is 3.90. Milord, the Chief Justice gets it.
Yes.
3.90. This is the rate that we have taken. And dissatisfied with this rate, Milord, we have gone up. Our own corporation, the next one, that is, Milord, Telangana Genco, the rate was 465. And we have gone up. Now, I can show you, Milord, our approvals from the different ERCs, etc. But that,
Mr. Rothi, this will really be a matter of your defense before the Commission of Inquiry, because you will be heard by the Commission of Inquiry.
The point is this, Milord. Can there be, Milord, an inquiry in respect of what is pending before the two courts? That's the question. This cannot be a matter of public importance because it will amount, whatever you call the inquiry, it will amount to an overreach over the judicial process. And therefore, Milord, it will be violative of the principle of separation of powers.
So
the courts or the quasi-judicial authorities will decide against which an appeal lies to the Supreme Court. Nobody can interfere.
Matter of fixation of tariff is pending before APTEL.
Yes, and Milord, this was preceded by both the ERCs of two different states, accepting the fact that yes, this is Milord a PPA. My state accepted, Chhattisgarh accepted, but Chhattisgarh ERC said 3.90, against which I have gone in appeal. So, Milord, the entire matter is covered by the judicial process. And these tribunals, Milord, are in lieu of the High Court. And an appeal lies to this court. It is my respectful submission, Milord, that there can be no interference with the courts of justice. This will sully the courts of justice. So
anything else? What else, Mr. Rothi?
Now, Milord, the third is the press meet. Your Lordship turns Annexure P20. PDF 329. Yeah. Kindly turn, Milord, to Annexure P20. Now, Milord, your Lordship finds this is 4th of May.
11 June.
Sorry. On the next page, 303 P20. Milord, your Lordship may note before I read it, I had to submit a reply by 15th of June. That date had to come. So reply will go, then proceedings will be held, then Milord, hearing is held by the judge. That's how the procedure is, Milord. We have seen it in the commission. This is well before even my reply. Now see this, Milord. Extract of press conference. See, Milord. Press reporters will be informed about details of what happened in the commission so far. PPA, Badri, Yadari. All the three were awarded without tender, awarded with direct negotiation, firstly to Chhattisgarh, secondly to BHEL. Every person, Milord, is an authority of the government of India. What crime have I done that I should face, Milord, just as a matter of political vendetta is my respectful submission. We have identified 25 officials and unofficials who have been involved in the contract. Notices were served. Replies were received except from Chandrasekhar, former Chief Minister, who is, Milord, asking to supply by so-and-so. On the basis of information gathered. And so your Lordship says 15 June, he recognizes the time. On the basis of information security gathered after interaction with former CMD, present CMD of BHEL, Genco, and the Principal Secretary, we asked them in what circumstances the contract was signed. They stated the decision was taken by the then government. Genco and other agencies were not involved in the contract. Next page. Yesterday he said this, that, or the other. See the third paragraph. In the meanwhile, this is Milord gross. In the meanwhile, MOU was executed, Milord, with the state of Chhattisgarh. After that, a PPA, which is not from their company, in which government officials are not involved. This is absolute perverse. If there is, Milord, an agreement between two states, it has to be signed by government officials, and it was signed by the Principal Secretary. That, Milord, your Lordship will get at page
250.
at PDF 220, just turn to 220. The whole thing is, Milord, it reeks of political vendetta. What do I expect from this commission? He has determined everything. About officials, I've asked the officials, I've spoken to CMD, BHEL, I've spoken to this, I've spoken to that.
They go through the bidding process, the whole market.
Milord, it goes on and on. It goes, see, Milord, the next page which I was reading, the next page. See the first sub-paragraph of the next page. Question is why tender was not adopted? Due to acute shortage and emergency, nomination was adopted. But as per record, power plant is not, it's under construction. Coming to Bhadrari, throughout India, there is supercritical technology. But here, subcritical is adopted. These are not matters, Milord, of public importance of a case. Now, see, Milord, last line of that page. I have my own doubts about completion of railway line. How can he have doubts of his own?
Where is that?
Last line, Milord, of that page.
Page 305.
It is, Milord. 331.
You see, one more thing.
Just turn to Milord 331.
The question is that why?
I was reading, Milord, middle paragraph. See this, coming to Bhadrari. He has already come to a conclusion, Milord. Sorry. Kindly turn to 331. It doesn't end, Milord. It gets better and better. Just turn to 331. My Lord, the Chief just ask a question. PDF 331 is a part of the press conference. See, Milord, middle paragraph. Coming to Bhadradri, where a power plant had to come up. Throughout India, there is supercritical technology, but here subcritical is adopted. Subcritical causes not only pollution, but economic loss. We have arrived at a preliminary estimate that the loss is so much through extra coal. It was done for the reason that we will get immediate access. But the government has already established a supercritical and we got information. Coming to Jadadri, what is left to determine? Lord, my reply is not there. Now see, Lord, last three lines. Sorry.
Mr. Luthra, the press note is not just an account of what has happened. That all right, we have issued notice that they will file replies. The press note prima facie does indicate conclusions or observations on merits.
Therefore, I want to clarify this. I want to clarify this. There's not that at all.
You are appearing for
the state.
Oh, sorry. And Mr. Luthra is appearing for
the state.
Oh, yes, all of you for that. Sorry, Dr. Singh, we thought Mr. Luthra is for the state and you are appearing for the. We would have not
He's for the commission, R1 is state, R2 is commission, R3 is the learned judge. He's for the commission. I'll just give you a few minutes.
For the commission and you're for the judge.
No, we are both for the state.
Both for the state.
Anyway, let me just point to
Dr. Singh, there are observations here directly.
No, Lordship heard him for at length. Just give me, this is not at all. Lordship, just give me a few minutes.
Let's read that
one by one. No, let me deal with it one by one. First and foremost, the document itself, which issues it in the beginning, appoints the commission, see that. My learned friend says it overlaps with other issues. Just see that document.
No.
287.
We'll just look at this as a standalone document, which has been issued by the press conference.
Immediately, in 2 minutes. Just first see 287. Because I'll come to the press conference immediately. Give me 2 minutes. Well, his first point is, it is sad and quite amazing that 70 years after Dalmia, it's amazing, in 1958, Dalmia decided Mr. Rodgi's point about definite issue of public importance. 58 Constitution Bench, direct same point, para 6.
We are not.
So leave that, that's one thing is over.
We're not really impressed with that.
Yes.
Or on that judicial aspect, we would just clarify
I'm
that,
saying
and
because
we'll record
retired judge, so they use the word judicial. Now, third point, this commission was appointed for what? There should be no overlap. Just turn to page 287 for a minute. So first point is judicial. From your lordship asking me, I must clarify that the word judicial was probably wrongly used because the judge was there, retired judge. It doesn't mean anything except a fact-finding inquiry, as the lordship put it correctly, with great respect. It can't go beyond the Commission of Inquiry Act's boundaries. That's point number 2. Now, public importance, the lordship will note, R.K. Dalmia, para 5, directly deals with this point, that you are not the judge of definite matter of public importance, it must be only riots, it must be only this and all that. Now, the third point, Wallace, is this malafide. Actually, the approach to malafides or bias of the commission is very different, and fortunately for me has been decided A in Dalmia and 3 recent judgments. My learned friend raises an objection that this judge was appearing for the state. There's one objection, conflict of interest.
Not appearing for the state, but you know that
now this press conference.
This press conference, some extracts here seem to indicate, prima facie, we are hearing you. We have not formed a conclusion.
No, that's
very clear.
I must tell
that there are observations on the merits of the issues which he is going to adjudicate.
Therefore,
or where he is going
what
to
he did was, on the first day when he took charge in March, he issued this one pager, which is not on record, which said that I am just going to be interacting with the state, with the public, to tell you what is happening. He did it on the first day. That is
what is the date of the notification appointing the Commission of Inquiry?
14/3/2024. Note 4 dates first. 14/3/2024. 11/4/24. He says, I must keep you abreast of how I am proceeding. I have been given 90 days. Just see this one pager. Don't take it out. Kindly give it. Kindly give it. Give it to the other side also, please. Now, Malaz, I'm sorry, my apology.
State defending this.
This is just, by the way, this just says it started in April. Note 3 dates, fellas. In April, he issues notice to everyone. The erstwhile chief minister in April says, I'm electioneering, I need time. So he asks for time and gets time till 15th June. Would my laws note that? He does not challenge any writ. He says, I want time till 15th. Well, as he asks for end of June, he gets till 15th June. Well, kindly note the date.
For the state government, how is he defending what
Who will defend? The judge will come and defend here the commission.
I'm sorry.
Well, I don't understand. Karunanidhi, Dalmia, everywhere the state is.
You are
10
the
judgments
state
lordships.
That's all right. What will you just give us those dates so that
Yes,
for our
dates are important.
ultimately.
See what he's doing, Willis. This commission is formed on March. The date your lordship has got. See the March.
Then 11th April, what happened?
4.
This is a notice.
Then this, he says, I'm the first. I'm just letting you know how I'm starting, what I'm doing. He issues on 11th of April. He issues a notice to the erstwhile chief minister amongst hundreds of other people on 14th of April 2024.
Yes.
Hundreds. This is not a specific inquiry against Mr. KCR. It's against a lot of other people. Hundreds of issues. Now, Mr. KCR doesn't challenge it. He says, I'm electioneering. Give me time till end of June. The commission's terms are 90 days. They actually expire at the end of June. He says, give me time till end of June. Nevertheless, the learned commission writes saying, we'll give you time. Give me that letter. 4, 5. No, that's page.
We got it here. It's an
302.
page 3, yes.
It says, I can understand your electioneering and I understand your time for nothing else. I am giving you till 15th June, which is 15 days before the expiry of the term. He holds this press conference on 11th because of the 3-month embargo. And he says only facts. It is the word language. Your lordship is not bothered. I understand. It's only facts. It's common ground. No, it's common ground that we have found that there is no bidding. It is common ground by everybody. And rest are all facts. I'll take a lordship to it. But first turn to 287. I must disabuse the lordship of the overlap. 287 first. 287, then I'll come to that document of the press conference. It only states facts. And I must show lordship 3 judgments. Directly the same allegation, the approach to bias of a commission inquiry is very different by lordships. It is not this, including a press conference. Earlier judgment have had a press conference also. I'll show that.
Now, just see page 305. Just see page 305.
Very well.
Actually, see bottom of page 304.
Yes. 304. May I read from 300 itself?
In the meanwhile, MOU was executed with Chhattisgarh. After that, Power Pages agreement was executed by CPDCL, in which government officials was not involved. Shri Arvind Kumar Garu.
This is what he's doing is summarizing what he has found from the responses. Just come to page 301. Give me a minute. 303. 303. Please come to 303. Well, let me just place it in my sequence. The only one para which is about KCR is the second para. We have identified 25 other officials. Replies were received from all except Mr. So-and-so Garu, former Chief Minister. We are addressing him to submit before 50. That's the only para about him. Now, Malas, he discusses former CMD. This is the excerpt only. This is not the complete thing. Now come to the next page, 304. Every sentence is, Malas, a factual narration of what the replies say. It is not put like that, but lots of, the only replies. He says.
Now just see, all right. We get the point that 304, he is really paraphrasing what Sri Suresh Chandra stated.
That's the problem.
All right. Fair enough. Now,
sometimes done loosely, but
look at page 305.
Yes, now let's go there. The question is, why did the tender process not adopted? So it's admitted. It's a nomination for 3 tenders. And one more thing.
They are also not saying tender was.
No, one more thing, Manas.
But just
one of the 3.
Let's read it slowly now.
Slowly. One sentence before that. One of the projects, the equipment is admittedly, advisedly subcritical on the ground that the critical will take 5 years to build. They buy subcritical, which your lordship knows today under environmental law, ashes and all generations, so your lordship doesn't appreciate it. The subcritical for 2 years excuse is actually made in 7 years. That's the third para of page 287.
Let's
now come to this first. The question is that why did tender process not adopted? Due to acute power shortage, in emergency direct nomination was adopted. But as per the record, the power plant is not in existence. All factual, Malas.
No,
it is
but
under
as per the record,
yes,
the power plant is not in existence.
Yes.
It is under construction.
Yes.
It was started somewhere in the year
2017. It was supplied for 3 to 4. All the replies, Malas. After that, it also stopped. We need to check the entire process, how much loss occurred.
That's exactly what he has to inquire into.
No, we need to inquire. He's saying we have to check.
But how much loss has occurred? So that means he's saying that loss has occurred. We'll now inquire into how much loss has occurred.
Well, he's saying that I am trying to, this is the issue arising, I will inquire. But it's like framing an issue. When a lordship frames an issue, this will be an issue. That's the whole point of a commission of fact-finding inquiry. It can be clarified in a minute, but just come to Bhattacharya.
Before that, the result is that there is a financial implication.
Yes.
And we have not worked out in detail. According to the information given by them, costs will be very heavy.
These are the replies which have come. He is not giving any finding. Well, how can he give what he's doing?
But the question, once again,
may I say,
Dr. Singhvi, the question is that why did tender process was not adopted?
Yes.
Thereafter, when he says that, it was supplied for 3 or 4 years, after that it also stopped.
All that has happened.
We need to check.
May I just say very in a lighter vein? This is what happens when you are trying to be extra transparent. He's actually summarizing. There will be some loose language.
Now look at.
He said, I've received the replies. The replies say this. Yes, come to Bhattacharya. Throughout India, there is a supercritical technology. This is very important. Please read this with 287. 287. But here, subcritical has been adopted. Subcritical technology causes not only pollution, but we have economic losses. Some persons, he's got reports. Expert reports have been filed. Persona estimate 1,000 crores. We have arrived at a preliminary estimate that loss will be 250. This is already done by a judicial minister. He's got opinions in writing.
But he has to deliver his report. But he has to submit his report. He's already at this stage without hearing anybody saying that the
it was done for the reason that we will get immediate access. Now, just give me a minute. Just pause here. Go to 287 for 1 minute. Your Lordship, read it 287.
Now let's read this and then there's more which follows.
Yes.
I have got my own doubts about the completion of railway line.
Yes.
Unless there is availability of coal, the railway line won't be able to finish.
Yes.
Apart from the officials, there have been suggestions from some other people too, especially Raghu so and so. We are trying to get their opinion.
Now, now just come to 287. Come to 287.
Mr. Dr. Singhvi, we are now at a stage where he has to inquire as the commissioner in the Commission of Inquiry.
What he's doing now, is summarizing two things.
He's gone beyond summary. He has gone beyond summary.
No. 287 is what I've been asking, Your Lordship. Come to 287. Come to 287
Dr. Singhvi,
for a minute.
He's expressed an opinion.
No, Malas, what is happening is, I have written a letter on him on 19th of June annexing a mass of material, the state government. All the evidence against everyone, including this petitioner. Yeah. And he's summarizing, Malas, some of it which has been given earlier on 11th June by experts. Come to page 287 now.
There are observations in that press note which seem to indicate that he has expressed an opinion on merit.
Come to 287 now. Now come to 287. Please kindly, I will ask you to come to 287 Malas for some time. Malas, kindly see that. See in light of that. My learned friend says it is nothing to do with statutory electricity and all that. Come to this. This is the terms of reference.
Yeah.
Whereas a decision was taken in 2014 to procure without open competitor, my lord says it's accepted. Next, point 1. Come to point 2. The second one was corridor 2000. Again, it is done below contracted capacity. Now come to most important para 6, which is point number 3. This is exactly what my lord is asking you. Come to para 6 first. Not for 5. Now, in para 5, your lordship has a Government of India notification that you must do through supercritical units. Third line of para 5. Now, my lord, correct?
Where do we get that?
Para 5, same page.
Of the recitals?
The same page, same para 5 of 287.
Government of India.
Yes. They are asking you to do supercritical units. Report of replacement of old and inefficient subcritical units.
You may be entirely, we are not saying that you are right, but this is exactly a matter which he has to inquire into.
So what he does is, he has got replies from me earlier, preliminary, and he's
assuming that he has got replies.
All that he has done is
at this stage, he can't hold a press conference and say that looks
he's summarizing. He's summarizing the replies. He's summarizing the replies. Now, let's kindly see. Kindly see para 6. Your lordships, may clarify that none of this shall constitute any finding in without the final. It's as simple as that. Otherwise,
now that we would have done that.
Yes.
But we have crossed that bar now by his expression of opinion.
No. Now, let's do things before.
Therefore, what we'll put to you.
No, please see the approach to bias in the judgments. 2 minutes.
After Dr. Singh, take 2 minutes. The eagerness of the state government shows what the real objective is very clearly.
Yeah, Dr. Singhvi.
Yes.
We are not with them on the first part, which is that
all the other
notification says judicial. We are not on this that there's not a definite matter of public importance.
Or the tariff commission.
Or that they have moved the tariff commission for the APTEL for increasing the tariff. But on the last part,
only on the press conference.
On the press conference.
Yes.
We are giving you an opportunity, Dr. Singhvi.
Yes.
You replace the judge on the Commission of Inquiry, appoint some other judge in the process, because there has to be an impression that that justice must be seen to be done. He's a Commissioner of Inquiry. He has expressed his view on merit.
May I seek instructions on that after I show your lordships two judgments. This is on inquiry commissions and bias. Your lordship a very different view.
Let us see
just
that.
very quickly, just turn to 1 minute.
Let us see the judgment.
Just first turn to
just note one date.
Can I just please?
The 8B notice to me was given on 19th June. After the press conference, what was given earlier?
Because he sought time.
1 minute.
What is the press conference dated?
11th.
11/6. I had to reply to a preliminary notice by 15/6. And the 8B notice, my lord, which is to affect my reputation under the law, was issued on 19/6. And 8B came only for this purpose, that if you have to, my lord, talk about somebody's reputation, give him a specific notice. That is 8B. This is where we stand.
Sir, may I just say, there are two slots.
8B is now going to happen.
Not 2 stages. First stage is under Rule 5, where we call for information, which is what the commission has done, which is what is sought to be summarized here, that this is the information. 8B is given to an individual when the conduct comes, look at the language of 8B. 8B specific. This is
That's
an
the
8B
8B.
notice. Please read.
We will
8B.
take these findings in 8B, not now.
Please read the findings in 8B. Not that stage is not come.
Kindly see the judgment on bias, on this press conference bias.
If at any stage of the inquiry, the commission considers it necessary to inquire into the conduct of any person or is of the opinion that the reputation of any person is likely to be prejudicially affected by the inquiry, commission shall give to that person a reasonable opportunity of being heard in that inquiry and to produce evidence in his
And he's
defense.
got time.
Provided that nothing in this section shall private credit. Number one, this is a notice given to him. He takes time. He keeps seeking his pension. All the commission says is that we issued him notice. He is yet to respond. That's all.
Now I must show Your Lordship a very robust approach to bias, including press conferences by the commission. That is very important.
The 14th April letter by the commission.
Yes. When he asked for 2 months till the end of June, 3 months.
That was in terms of 8B. He was asked to give a reply. He takes a month and a half, Lord.
These are 2
months in fact.
Pre-8B. Nothing can happen.
Real question
My learned friend
why
is
should we have held the press conference?
My learned friend is saying
What was the necessity?
that stop the commission before it has started 8B.
The commission is completely.
Your Lordship never stops the commission before starting 8B. Just by the loose language used.
Dr. Singhvi,
yes,
that press conference.
I understand, Malaj.
It was merely a press conference indicating the modalities which have been followed. We have issued a notice to so we are now going to place it for hearing on a particular.
I have no control. He need not have had a press conference at all. That is correct.
Absolutely.
I understand. But what was it for? What was it for? It was for summarizing what he received.
So a little untoward for a person who is a judge.
So that's why now just see the approach to bias on commission inquiry. Just see for 2 minutes. Just let's see that. Mr. Kindly hand over. Just see 2 or 3 paras. Keep it here. Copies the Come to para 10 and then I will show, cited in this, the High Court judgment where a press conference was raised as bias. That Your Lordship must know. It's a very different approach. Well, right from Ramakrishna Dalmia and Karunanidhi, successor governments are accused by previous governments. Your Lordship has gone through all that. Now come to para 10. May I turn Your Lordship to para 10, Manas? This is very important for me. In any case, the allegation that the brother of the chairman of the commission is a legislator belonging to or supporting the party in power and that the member of the commission is related to the IG of police are not sufficient to come to the conclusion lead to bias or conflict of interest. Look at me, Manas. I made a press conference for extra transparency, perhaps foolishly. That in terms of the commission, not me, the commission. Since there is no indication whatsoever.
You held a press conference.
Not me, Manas, the commission.
I mean, the commission held a press conference. And in the course of that press conference, really transgressed that line between.
Well, I will for a minute concede it. This should not.
Procedure and the merits of.
I will for a minute for arguments concede the spirit of what my Lord the Chief Justice is saying. But Manas, the idea is it should not become an excuse for him to get an undue advantage. Just see the judgment now. That's important.
I'm not a convict. I should get an.
Are not sufficient to come to the conclusion of lead to bias or conflicts if there is. Look at the seriousness of the charges, Manas. No indication as to the nature of influence of those relatively able to exert. It must be remembered here we are dealing with an inquiry commission under these are constitution benches cited, whose functions are well defined. As held by the constitution bench, a commission constituted under the Act is empowered to merely investigate recorded findings, make its recommendations. These recommendations are not enforceable propria vigere and before 8B. These fellows obstructing it before 8B. The view taken by Ramakrishna Dalmia reinforced by Karnataka.
In fact, if the learned judge had said nothing and he had.
Well, I understand. He's taking advantage of technicality. But I understand the spirit of what my Lord says. Different commissions act differently, different judges act differently. And your Lordship knows it better than we do.
Lord, this judgment is entirely against my friend. I will show you.
Parallel commentary, Mr. Now,
completely against.
In fact, this court went in Shamkant to the extent of holding that the findings are not binding on the court. While dealing with an appeal arising out of conviction and sentence, the police officer was the appellant in said case of it. Now come to Vijay Bhaskar Reddy. Next para, very important, para 12. 12 to 14 is bias on the part of the appointee. They fall under 2 broad classes. Bias are out of pecuniary, bias out of personal interest on account of judge's relationship. Then Manas, they quote from the treatise of Massey, certain relationship equation between the deciding authority and the party which incline him unfavorably. Though a contention was raised in Vijay Bhaskar Reddy, keep ready, Mr. Vijay Bhaskar case, keep it ready, that the principle has no application to the proceeding before inquiry, which are basically inquisitorial and not judicial or quasi-judicial or adversarial. The division bench held that the duty.
Lord, please see para 6
Mr.
first. Don't read a para after that. Read para 6. Allegations were made on newspaper reports.
I'm not on newspaper. I'm on, this is a separate ground. It has nothing to do with newspaper report. I've read 6 earlier. It has nothing to do with 6. I'm not arguing on newspaper reports. Well, at the, I'm sorry.
How do I get?
At the end of the day, this press conference comes under what head? Bias only. It is your lordship's perception that he has pre-decided there's some kind of institutional bias. These are much worse cases of bias. Now turn to
what is the press conference in that Vijay Bhaskar Reddy
Yes,
said?
immediately. 1 minute more on this. Exactly. There must be cogent, uncontroverted, undisputed material. The court cannot go by vague, whimsical and capricious. Applying these principles, Andhra High Court rejected the challenge made by. I am now saying I would not have done it. Your lordship would not have done a press conference. But the fact that he has done it is sufficient for your lordship to still uphold it and not give advantage to it. That's the point I'm making now. Now come to the next.
Had he not really made some observations on the merits of the issue, we would have left it at that.
Now let us see that.
But the problem is that there are clear observations on some of the
Well,
merits.
that one sentence of yours and my statement that this
Quite a few.
the inquiry is not started yet. 8B, this is
All
not
the more
binding.
reason why he shouldn't have said all that.
That's but
All
it
the
will
more
not bind
reason
him.
why he shouldn't say all that.
Bind anybody. Well, they kindly give this.
You see, Dr. Singhvi, it doesn't bind anybody. Let's also face it. What's the reality? It doesn't bind anybody, right? But 2 things. One, the impact of the report of a commission of inquiry does affect the reputation of a person.
Report will come
and
after.
that's why 8B contemplates a notice being given to a person.
Report will come after 3 months. This is not a report.
Whose reputation is likely to be prejudicially
Your
affected.
lordship is being asked to stop it now. The report has not come yet. Report will come after 3 months. It has started now. Now see, Malas, this new one, new judgment.
Yes.
See the new judgment. Malas, it is started now. Otherwise, the fact that all his remedies are open. He cannot have criminal prosecution on the basis of commission of inquiry. He cannot have civil consequences. Now come to para 39. Come to 39.
In fact, just see para 25.
Good, just see 39G.
When they say that even to a commission of inquiry,
yes,
the principle of bias would still apply.
Good. I am giving out the application of that principle. Now come to G, 39G. 39G. And this your lordships knows that sometimes people have quirky ways of functioning without necessarily having any bias. I mean, this is quite, there's no need for this. The manner in which the 4th respondent has been briefing personally the press of his choice to give wide publicity to the proceedings. This is very interesting. 39G, well, what has got? Now, this I would call quirky. The lordship may not do it. I understand that fully, and I understand the spirit in which the Chief Justice is saying so. It will be better. Now come to 40. Last 4 lines, 40. The submission of the report by the commission will not end the matter. The petitioners will not be without any remedy, even if they, suppose they indicts him in the final report. All his remedies are open, no civil, no criminal consequences. It's fact-finding for the state. 44. That's the whole meaning. And now come to 44. 44. Well, it's fact-finding for the state. It has no consequence of Mr. Rohtgi's line. None. 1 is appointment of the 4th respondent without reference to the Chief Justice, negative. 2, hostile attitude of the 4th respondent towards Congress High and the bias in favor of Telugu Desam Party. Much more serious. 3 is the next page, Malas. Conduct while functioning as the commission. Now, this is the G about the press conference. Chief Justice got it, Malas?
Yes.
Top. Ground C, D, E, F and G. G is the one which is the press conference. Aforementioned are relevant. Of these, F and G are denied. Grounds E do not relate. We shall deal. But we are of the opinion that these grounds are not enough to give rise to reasonable apprehension of bias. They may give rise to a vague suspicion. No reasonable person can have apprehension of bias. Now, let's look at the overall context. Let us assume that this commission is given 3 months more, gives 8B, he participates and he gets an order, a report which gives facts which possibly implicate him or find facts against him and 200 other officials. No civil, no criminal consequence occurs because the man had a press conference, which is possibly not required, totally unnecessary. He will read bias. Ultimately, my learned friend must bring the press conference into the head of a bias. He cannot say press conference per se, injunction, stop. The press conference comes in the same head which I am reading, bias. There is no other head. personal bias, pecuniary bias, institutional bias. Now, my lords, an error of approach, the way I function is erroneous, doesn't make it bias under the legal head. And my learned friend, my lords, doesn't actually challenge it till June. Now turn to 345. Look at the mass of material I have sent. I was asked to respond. I have sent, I am the state, fellows. At page 345 on 19th June, I sent a mass of material. That mass of material led to 8B notice.
Yes.
Well, on 19th June, on 19th June, I sent him the entire material with the state. On that basis, he issues 8B. It is starting now. What is actually happening is, I understand the psychology, your lordships are, psychology can't lead to a thing. Nevertheless, your lordship may consider one last submission. I saw instructions while I was arguing. Your lordship should not give any finding, etc. And I think your lordship could be persuaded by what I've said on the law. In the unlikely event the lordship is not persuaded, the state government has no problem, we can appoint somebody else. I saw instructions. But that should not be a concession. According to me, your lordships can say that this is not bias, and yet I am saying that we are appointing somebody else. This is in law, not bias.
What we will do is that
because it should not delay indefinitely.
We will record your statement that you're substituting the.
But it should be clear that I am not conceding a lordship is not finding bias in any.
I have something to say.
Finding bias. I am saying so that without prejudice, we are
prepared to have.
And two more things.
We are not saying that you should concede to bias.
Yes,
but you can certainly just replace the.
I'm saying so. And one more thing, without prejudice, one thing is important. Mr. Rohtgi's client should not take time indefinitely.
Yes.
And the 90-day period, this is not a game, where I come to the court and get extra time. Well, it's two.
I have something to say.
Otherwise, my lordship will have to hear the judge. It will be unseemly and all that. Why should lordship hear the judge? He is the judge. He is the judge.
Yeah, then Mr. Shankar, they are themselves replacing the judge. We need
without prejudice to anything. But two conditions. 1 minute. The inquiry will continue from wherever it is now today. Not that he has to inquire again the same material which has been filed. Your lordship knows 3 months filing has been done. Second, my learned friend should not take unnecessary. He has 8B notice, he must reply and participate. It's not that he will take a judge.
Therefore, no difficulty. We are not saying that the new judge cannot
only
start from the same.
I am making this statement. Sorry.
Just tell us after lunch who you are appointing, so we'll record that.
May I just make two brief submissions?
Give the name.
We can just say that if you.
I want
just 1 minute, Mr. Rohtgi.
Yeah, sure.
You have got the lunch after lunch. Sir. Judge, the name. Either me or my learned friend report your lordship.
I just, your lordship.
At 2 o'clock we'll report the name.
I just need
I wish
2 minutes. Just 1 minute.
Apart from the change of name.
I just need 2 minutes to address you on that press conference business. I think that's clear there somewhat. I'll just explain, just 2 minutes. The terms of reference in detail refers to what the issues are on which I must investigate. Of those 3 power plants, the first one, the Chhattisgarh one, the terms of reference themselves specifically refer to loss having occurred. Now, I am not going to inquire when the terms of reference are saying there's loss that's occurred. I'm referring to that when in my press note, I refer to it. Secondly, the 3 names that I've referred to in my press note, that is one, Joshi, Suresh Chandra, Arvind Kumar. Their statements are annexed at pages 370, 376, 383. If you look at the press note and compare it with the statements which are already recorded, which are there on your lordship's record, you'll see that that is the basis for me stating X, Y, Z. But most importantly, this allegation is coming from one individual after I've examined 24 witnesses. That one individual who's a witness who has not given me a response is alleging bias by me against him, for which he needs to show 1 sentence by me against him. 1 sentence. This is no, I have said nothing about him except to say that he has asked for time.
With the law on bias, which I cited already, as being what it is.
Who has?
Concept of bias in law is very different.
The power plant that was, sorry.
Dr. Singhvi is this, that we will record at 2 o'clock that your decision as a government, you can tell us of substituting the.
The name will tell your lordships,
Yes.
my decision.
And it will continue from the stage which has been reached.
That's right. And no,
But no aspersions cast on me, I hope. Because now suddenly in the Supreme Court, they annex orders of my appearance in this court. And they start saying that is the reason why there is bias.
State government, your lordship can never be a judge, then. Your lordships, because you're appearing for state government.
For the state government. I have not appeared for the state government.
We will record. He has been a former judge of.
But fair.
Not argue.
Yeah, that has not been argued at all or pressed. So we'll only record their statement, so we don't have to go into the issue.
But that is that's punishable under
I will
10A.
say, I will say two things only.
One sentence before he says,
Because
without prejudice.
Judge starts from this point, another point should be left to the judge.
No.
This is not a court. Number one. 1 minute. Shows non-eagerness and desperation. Number two, I have something to say on the terms of reference. One of the references is to fix responsibility and find out the financial thing. How can you fix responsibility?
That is again a non-binding term of reference. That is only a recommendatory body.
Under the law,
Obviously.
It is. Somehow, this Lord, the ex-chief minister by the new chief minister. That's all there is to it in this case.
My formulation may be clear. Without prejudice and without accepting any of the allegation by the petitioner, I have made a statement that we will replace and the learned honorable judge will be so and so. That's my formula.
We'll come back at. Then on the first 2 points, do you want us to deliver?
Then your lordship needs similar, why should I raise a point?
Exactly.
Lordship will
We'll be
decline.
right.
We'll come back at 2.
हेलो हाँ बोलो चेक चेक करा ऊपर से ठीक है चालेल हाँ 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 तो बाजूला
કંપનીમાં કશું છે નહીં એમાં ચાર્ટ ડુબાડ બધું મરી જાય ને પીટીપી માં લઈને જ જઉં છું એ બેંકમાં પ્રપોઝલ ચાલે છે અમે એમાં જ મરી જવાય છે ને આ બધું
Penalty or best.
નો સ્કેન કેવું રાખ્યું પછી સાઈન મારી તો ડિફોલ્ટ થાય છે એટલે login, madam. बोलो था I hope these document consider the processing of work and waiting for the Indian income tax for it according to this must be filed on the Indian.
Yes,
Suggestion before my friend.
yes, yes.
Lord, let it be a judge of this court.
So let it.
Let it be a judge of this court.
Commission of inquiry, well, act, I have to appoint,
this
state
creates-
has to appoint. Let us not
We are from
expand the
that
debate
state.
now.
Person is
Commission
also
of
from
Inquiry
that
Act, where is the government of opinion? That will be substituted by Supreme Court.
It's not like an arbitrator where we can just appoint someone.
Not some kind of
That's all
arbitration
it-
going on.
But Milord, your lordship must clarify the judicial part.
Yeah, that will.
After the proceedings just before lunch, the judge has in fact signed off and sent me a letter. If I can place that before your lordships, just for your lordships.
Same thing happened in the case of NCL.
Lordship can just see that. Yeah.
Good enough. Yeah, I was also told about the real reason in the first paragraph. It's a very unusual and unfortunate. Anyway, we will appoint. Close the matter on that without prejudice.
We'll have to take consent.
We have
And I
to
may
find
also
out.
say that press note that was read to your lordships, that is not accurate. We have not placed our press note. That is it was originally in Telugu. Translation, it's not the accurate translation. So I know a lot of stock has been placed by your lordships on that. I think it's a little unfortunate, but this is how things stand and it's best that we.
Because also, Malas, the person we inquired among 200 people, 100 people should not take unfair advantage. Your lordship's objective is never that. There are a technicality, somebody gets away with the advantage.
Now, who are you appointing?
Well, it's the actual name I don't want to give right away because we will take the consent, find out. So I'll give that name on Monday. Your lordship has two options subject to my lord's kind discretion. One, your lordship will dispose of the matter according to and I'll notify it by Monday. Or your lordship will call this on Monday. There's only
No, we'll just say, we'll just dispose.
no need to call this on Monday.
During the course of the hearing, Mr. Gopal Shankar Narayan, Learned Senior Counsel, appearing on behalf of the
Respondent number 3.
of the third respondent.
Respondents 2 and 3.
2 is the commission, 3 is the learned judge.
Of the second and third respondents, into brackets, the Commission of Inquiry and Chief Justice L. Narasimha Reddy, bracket state has placed on the record a communication indicating that the third respondent has indicated that has stated that he does not intend to continue with the Commission of Inquiry, that he does not intend to continue to act in pursuance of the notification appointing him appointing him as Commissioner.
As Commission 1.
Commission of Inquiry. Would stop. In view of this development during the course of the hearing, Dr. Abhishek appointing shortly appointing a former judge.
Well, it's a fresh notification, not to say, because otherwise they'll say the whole process starts from notice.
A substitute. A notification. A notification substituting the Justice L. Narasimha Reddy with an alternate appointment.
Deeply obliged.
All right, we'll stop. Moreover, it has been clarified. Moreover, it has been clarified by Dr. M. Singhvi, appearing on behalf of the state of Telangana, that the expression judicial in the notification dated
14 March.
14 March 2024.
Travel beyond this.
Notification date 14 March 2024 was intended to denote, refer to the status of the one-man commission as a former judge, and that the notification constituting the commission of inquiry would continue to fall within the ambit and purview of the Commission of Inquiries Act 1952. Check for the date.
Continue from that stage.
Why should this be said? That
the judge will decide. He's going to on that ground.
I'm sorry, Lord, this is not a.
We are saying in view of, once again, in view of your statement, we are just saying that in view of your statement, this petition is disposed of.
Exactly. We will do whatever he has to do.
Once we say substitution, that judge can continue from the same stage.
I don't think your lordship intends re-understanding.
Yes.
But because people take this technicality, why did you not start de novo on a clean slate? Why did you not issue fresh?
Lord, that is not.
In the March to June time is taken by Mr. Rodgi's client. Let us reinvent the wheel and have another 3 months.
So, Lord, I will say whatever I have to say. This is not fair.
Every witness statement, hundreds.
Oh,
why should this court say?
The new, but
will not create any malice.
But you know, in his petition for us to say that, we just leave it at that. The new judge who's appointed may continue if he feels we have not said, therefore, we have not said fresh notification.
Not put it like this.
We have
to substitute so learned judge to continue with the commission.
No, I'm sorry, my lord. That should not be.
But Dr. Singhvi, you can say that in your notification.
My lord.
I am trying to obviate Balal's challenges which are a waste of court's time or technicality.
Can we prevent any challenge being brought? But you can say that in your notification.
We'll say that. We'll say that in our.
Suppose the judge doesn't want to continue. You are forcing it on the new judge. How can you
not be saying substitution in terms of 3-2?
There's a provision specifically?
Lord, 3-2 says commission may consist of one of the members appointed by the appropriate government, and where the commission consists of more than one of them may be. So, Lord, that's how it is.
No, it's not a substitution provision.
That's not so, my lord. Please.
That's not a substitution. All right.
Very well.
The petition is disposed of in the above terms, since no other point has been pressed. We'll say since no other point has been pressed.
Yes, my lord, should say that.
Otherwise, you'll have another round of those.
I only wanted, subject to lordship pleasure, that clause which said to fix responsibility is really beyond, my lord, the scope of fact.
It's again really, it's recommendatory. No, that part is recommended.
Lordship may say that clause 4 says that fix responsibility and the financial part. That is not, my lord, limited.
Because we'll then have to decide the whole issue.
Yes, I don't mind. Lordship may decide. I don't mind.
We'll leave it at that.
As a lordship pleases, I will not.
The state's representation was not shown, or that may be shown. For some reason, the portal is not that should be.
Appearances, you can ask the juniors to give the appearance.
We gave it yesterday.
No, Lord, this is a very small issue. I am the owner of, Lord, the premises.
Yes.
The respondent was a tenant.
Yes.
Lord, the lease was terminated.
Yes.
The security was 20 crores. I had to give 20 crores back and get my property back.
You didn't give the 20 crores.
I did because, my lord, they had virtually, my lord, destroyed my property.
Right.
I said you must put it back in order.
Now, your claim was rejected and their counterclaim was allowed.
Yes.
Now, what is the
partly.
What is the quantum of the counterclaim which has been allowed for return?
I'll tell
you. How much? What is the quantified amount?
My lord, their counterclaim is 22 crores because 20 crores, my lord, was the security. So
now,
basically,
now you want possession.
I wanted possession. So the arbitrator said that when you return 20, you will get possession because I am good. The yearly rental is 50 crores under this lease. Today the rental will be 100 crores. It's a huge property in an SEZ. Now I said that from 20 crores, there should be a deduction of the damage that they have caused. They have vandalized my property.
Which was rejected.
No, which was allowed to the extent of 2.5 crores. I said it should be 9 crores, etc. So, my lord, this dispute ultimately went to arbitrator. He said 2.5 crores, not 9. And this is how you return. And he said, till you return, they will retain possession. So the fact of the matter is, not a property which can fetch 50 crores as rent.
And they are still in possession.
And they are not using it. So it's lying empty, my lord, with a lock, neither to their benefit nor to mine.
And such a condition, according to me, should never have been imposed. Property is worth 500 crore against this 20 crore. For whatever it is, my lord, this dispute went on, COVID, etc. happened. So now I went to the court and said, my lord, I have filed objections. They have to be decided, my lord, in 34, etc. I went to court and said a very simple thing, that against 20 crores, even if you assume 20 crores,
but see, para 11,
yes,
the learned judge rightly says, I have put it to Mr. Sibbal,
yes,
that possession of the leased premises may be recovered by the petitioner
if you
on depositing the amount awarded by to the respondent in court.
But then
so you have to give security for the amount which has been
correct,
awarded.
absolutely correct. So I said, my lord, I will replace this property by another property.
No.
What is wrong with that?
You have to deposit the amount in court then.
No, my lord, with respect. He said,
you want your property back. We'll give you a property because you're right. In that 1 year that the matter remains pending, suppose you might get 50 crores or 100 crores by way of a
Yes.
We don't know what the value is.
Whatever.
But therefore, but then you have to really do this.
So what
to get your property back.
Correct. So what I said,
Property is not theirs. You can raise money on the security on a mortgage of the property.
what I said was, you give my property back, and in lieu, I'll give another property as security for 20 crores.
Deposit the amount which has been awarded against you.
It will end the matter, my lord.
No, he will not withdraw it. It will be in court.
I understand that, Lord. The arbitrator has recorded a finding that there was breakage and damage to the property at the. He said 2.5. According to me, it is 10. On this dispute, my lord, this quibble is going on. I am only suggesting that if I replace the property by another property.
Not another property. You have to put. There's a money decree in his favor.
But your money decree is subject to 34 against.
But today it's a money decree. It has the effect of a decree.
Agreed. But not I have.
So you have to make good that decree, and we quite see you should be allowed to exploit the property. Why keep it in his possession?
No, it does.
Because if it's in his possession, he must be also letting it out, or God knows whether they are letting it out or not.
No, I will, my lord, then I'll have to, my lord, repair the property and then see what I have to do.
But you will get your property back against the deposit of that amount, and they will not get the money. If they want to withdraw what you have deposited, they'll have to issue a bank guarantee. Eventually, that will be decided by the High Court. But usually, High Court will tell them, all right, you withdraw against a bank guarantee. But you will get your property, which is worth much more than 20 crores.
Because of the value of this property, I was giving another property, my lord, which is valued much higher than this 20 crore. I would have given property worth 100 crore. I want this property back. I give you another 100, including title deeds deposit, my lord. Lord, then your lordship might only say this, Lord.
Yes.
That in the event I deposit, Lord, I'll be entitled to get my property. I don't want another round to start. Unnecessarily bitter litigation going on. Can you just make that observation?
No, but then we'll have to hear them because now your application is dismissed.
No, this Lord.
We can give you liberty to go back to the High Court with an application that you are willing to deposit.
Your lordship might say that. So it will expedite it, my lord. This actually doesn't suit anybody.
That's much better.
It suits nobody, my lord. It's neither my client nor me. Your lordship might just say that.
By the arbitral award, we'll just write a short order. By the arbitral award, the claim of the petitioner was rejected, while the counterclaim was allowed in part or wholly.
No, my lord, their counterclaim.
Was allowed.
Their counterclaim.
Just shows the award.
Both claims were partly allowed. Your lordship, your lordship will see that. My lord, volume 3.
Page. 1 second. We go to the.
UPF is 8.1. What do you see? Your page 927 of the volume 3.
927.
Yeah, I'll give you the PDF. 927.
What is the internal page?
927.
All right.
It's, my lord, the third last page of the award. Para 102.
In the arbitral proceedings, before the sole arbitrator, the petitioner was the claimant while the respondent was the petitioner was the claimant. Full stop. The claim, the dispute between the parties, uske pehle likho, the dispute between the parties arose out of a lease deed in pursuance of which the dispute between the parties arose out of a lease deed in pursuance of which the respondent had paid a security deposit to the petitioner. Full stop. The respondent terminated the contract. The respondent issued a notice of termination and sought a refund of the security deposit. Full stop. The dispute between the parties was referred to arbitration. The arbitrator, the sole arbitrator, by an award dated 1 November 2023, allowed the claim of the petitioner in the amount of rupees 1,50,67,568. ये आपको मिलेगा PDF पेज 950 पे. Allowed the claim of the petitioner.
Three claims.
Allowed three claims of the petitioner. I just saw that. Yeah. Allowed three claims of the petitioner. Full stop. The counterclaim of the respondent was by directing the petitioner to refund the respondent the lease rent security deposit in the sum of rupees 18 crores 26 lakhs 18,051 and the maintenance security deposit in the amount of rupees 2 crores 41 lakhs 96,564. Page 951 ko milega. And the electricity security deposit. ऐसा कर लीजिए. The counterclaim, we'll just put it in a much shorter way. The counterclaim of the respondent was allowed in the aggregate amount of rupees 21 crores, 34 lakhs, 14,615, together with interest at 12% per annum from the date of the deposit of the security deposits till actual refund. Where is that written that he can hold on to the property until until the counterclaim is paid?
903.
The arbitrator also directed that the respondent would be entitled to retain possession of the leased premises
PDF 924.
Until the counterclaim is paid.
Para 52.
Into brackets, paragraph 52 of the award. Correct?
Para 52.
Right.
Yes.
Next. Petitions under one petition under section 34 by you. Only one petition, right? The petitioner has instituted proceedings under section 34 of the Arbitration and Conciliation Act 1996 to challenge the arbitral award. We'll stop. During the pendency of the proceedings, the petitioner moved the High Court for permission to provide security in the form of alternate immovable property in substitution of the premises which form the subject matter of the arbitral award. Full stop. During the course of the hearing, full stop, the civil judge in the impugned order recorded that during the course of the hearing, the court had inquired of the counsel for the petitioner, I had indicated, don't say had inquired, had indicated that possession of the leased premises may be recovered by the petitioner upon depositing the amount awarded to the respondent in court, subject to the result of the petition. Full stop. This offer was not, the petitioner was not agreeable to this course of action. Full stop. Hence, the IA was dismissed, bearing in mind the provisions of clauses 7C and 11E of the lease deal.
Well,
next. During the course of the hearing, we have indicated to Mr. Mukul Rohatgi, Learned Senior Counsel appearing on behalf of the petitioners, Mr. Devdatta Kamath, Learned Senior Counsel, that we are not inclined to interfere with the order of the Learned Single Judge. Stop. We are of the view that the course of action which was indicated in paragraph 11 of the impugned order was eminently the correct one to adopt. Full stop. However, it appears that the petitioner was then not agreeable to depositing the entire amount awarded towards the counterclaim in court. Full stop. At this stage, Mr. Mukul Rohatgi states that the petitioner may be given liberty to move the High Court so as to indicate that it accepts the course of action which was suggested by the High Court as recorded in paragraph 11 of the impugned judgment and order dated 13 May 2024. Stop. We permit the petitioner to do so and to move an IA or any appropriate proceeding in that regard before the single judge.
Instead of saying that I'll deposit or follow the course, you also only say that I will take appropriate proceedings in the report.
The
petition, whether they do, they don't do,
right.
So we just correct that part.
Yeah, we clarify that in the event that the petitioner seeks to obtain seeks any relief in the nature of the possession of the leased property, it would necessarily have to move the High Court in terms of the course of action which was laid down by the High Court in paragraph 11 of the order.
So the earlier paragraph may go.
We'll just clarify while editing it. The petition shall stand disposed of with the above clarification.
Wait, please, Your Lordships. Not in item 20.
Yes.
I adopted the two children by a religious ceremony under the Hama on 9/1/2020.
Now, Hama is not governed by the JJ Act.
No, my lord, it's independent.
56(3) specifically.
Absolutely. And 56(3) leads to 60.
Now, the only problem,
yes,
which I see, there is this regulation 67 and 68.
Absolutely.
Under the JJ Act.
Yes, my lord.
Now, that specifically says that you have to have the no objection of the agency in that country.
My lord, no. With respect, no. If your lordship may see 67, this has been going on for quite some time. Now, what is going on? Very briefly, I explained.
You have adopted your brother's two children.
I adopted.
How old are the children?
Lord, they are 5 now. I have been with them since birth. I am sitting in UK. They are sitting in India. We are separated just because of this Kara business. Lord, what is happening? Lord, first of all, Lord, they are getting the date.
Your client is single.
My client is single. She doesn't propose to marry. I have adopted my brother's 2 children. He is divorced. His wife is dead. Lord, what happens to the children? He is bringing them up with the help of my mother. The children don't know who is the father, who is the mother, and who is the guardian.
But how do we get around regulation 67?
I give you the answer below. Lord, what is happening? If your lordship may just have, first of all, your lordship may have section 60 on page 19. Lord, the answer, sorry. My lord, can I explain what has happened? My lord, there were two judgments of the Punjab and High Court. I was in amicus there. Then there was a judgment of the Delhi High Court, which said once there is a Hindu adoption, Kara can't do anything. They just have to get a verification if they want to. District magistrate issues a certificate. Lord, they have gone to the extent of taking out the word court and replacing by a word district magistrate, which is actually done murder to the adoption. One, two, that part. Now, my lord,
that has been actually stayed by the Bombay High Court, no?
my lord, but it is getting chaos because the district magistrate has no application of mine. He just stamps a certificate and gives it. My lord, it has become a laughing stock, honestly. Now, my lord, that part. My lord, what they did after these two judgments, these judgments said you have nothing to do with the adoption under Hama. They are irreversible. Once giving and taking takes place, that's the end of the story.
Then they brought these regulations.
Yes, then they brought these regulations through the back door. And Lord, effectively what they have done, your Lordship must expand this in Temple of Healing. They have eroded the act. Lord, they have actually demolished Hama. They have demolished the JJ Act. Now, your Lordship may have with me section 56 on page 80. First of all, it says that nothing in this act shall apply to the adoption of children made under the provision of Hama. It's a clear go-by. Now, your Lordship,
Malhotra, what we'll do is we'll issue notice.
Lord, can I just make one submission?
Because let the government
Yes,
also come
Oh,
forward.
Lord, I just want to make one submission.
Also, you know, look, your case appears to be a very genuine case because the father's sister,
Yes,
the paternal aunt,
yes, my lord.
wants to take the children. She has taken the children in adoption. She lives in the UK.
Yes, my lord.
He wants to take the children to the UK. The only problem, I'll tell you, I was just discussing with my learned colleague. This is a Hama adoption.
Yes, my lord.
Once they go there, the children will be entitled to the benefit of, say, National Health Service, NHS, whatever. Perhaps sponsorship by the agency in the UK may be necessary, because if the UK authorities don't recognize this adoption, suppose a child falls sick, you will not get NHS.
Lord, I'll give you the answer to this. My lord, I challenge these regulations.
Or social security.
My lord, just a moment. I challenge these regulations in the Punjab and Haryana High Court with a father, American father, who was to take two children or take a child who was 2 years old and sitting in India for 2 years. Lord, what they have done, the Kara gets a support letter from the embassy or the High Commission in Delhi saying, do you prove this? The American embassy says, child has been with the parent for 2 years, he qualifies for IU-120, you are in. They write, the Kara writes to the British High Commission. They say, we approve this policy. Kara does a district magistrate certificate, gets a report. I have an order of the Punjab and High Court where this is done. Now, there is a matter in Delhi High Court. Kindly come to page 26. I have reproduced the content of an affidavit which Kara has filed in the Delhi High Court. This makes it very clear. But wherever there is no 5 and 17 is not fulfilled, they say, we will give you a conformity certificate. Because the Hague Convention in Article 23 and 37 itself says that if there are dual systems of adoption.
To Kara and make it returnable.
Can I just point out page 26? My lord, on page 26 in the affidavit.
You can, we will issue notice and keep it. Ms. Bhatti is traveling this week because yesterday, some other matter they had mentioned that she was abroad. So we'll make it returnable maybe next week. And give a notice, advance notice to both the Kara and an additional copy to Ms. Aishwarya Bhatti. So that we will.
And Lord, one thing where the High Court has gone wrong is.
Notice, we'll say issue notice, returnable on Karo. Liberty to serve an additional copy on, besides the central agency, liberty to serve an additional copy on Kara, central wo jo hai pura naam dekho. Ms. Aishwarya Bhatti, Learned ASG, is requested to assist the court.
And 2 and 3 are the registrar of in the Tamil Nadu, the collector who have to do this checking.
Yeah, you should notice it. Liberty to serve the standing counsel for the state of Tamil Nadu.
Please, Your Lord.
As regards respond numbers 2 and 3.
Not just a point of mention. They have issued 68 support letters in cases like mine. They give a support letter. They say, go and get it. We will get a letter from the embassy. We'll do a verification.
All right, we'll see what to do here.
Lord, the procedure which your Lordship is suggesting and is going is for orphan abandoned surrendered children for fresh matters. Now, if I go to my adoption agency in the US, I start all over again. So it's demolishing a Hindu adoption.
All right, we'll see.
Please, Your Lordship. Extremely grateful.
31.
But Lord, Your Lordship must flag this issue in Temple of Healing. Yes. Because it started there, but it went in another direction. I will be happy to assist if Your Lordship needs me. Great.
31.
Yes.
Diwan, how long will 29 take? It's an after notice.
No, it's a short matter, brother. I mentioned this for urgent relief. I'll just indicate what the problem is. There are 2 IAs which are listed today. Your Lordships have those?
My Lords, before Mr. Diwan will start, may I just mention, my Lords, difficulty, my Lords, today, my Lords. Inform the other side in the morning, my Lords, for some accommodation for today, my Lords, I'll be requesting, my Lords. I've informed the AOR, my Lords. The matter is.
Sorry, Mr. Yes, your voice is breaking. We can't follow what you're saying.
I'm sorry, my Lords. My Lords, am I audible now, my Lords?
Yes.
My Lords, I'm seeking accommodation for a day, my Lords. The matter has suddenly come up in the supplementary list yesterday late evening, my Lords. We were not able to engage, my Lords, senior, my Lords, and my client are in jail, my Lords. We were not have to take certain instructions, my Lords. Lord, may I have it next Tuesday or maybe, my Lords, Thursday?
No, I'll just indicate if my learned friend is appearing for the original respondent or for the newly sought impleaded parties, because I am really seeking interim relief against an impleaded party that I seek to implead. I'll just indicate the point, because this final civil appeal will take its time for, Your Lordship is correct, that is a reversal case which I will explain. But the reason why I had to move over here was that in a parallel insolvency proceeding, I am being checkmated and my entire claim is being disregarded by the resolution professional, though 1,200 crores are owed to me because of a certain order of the NCLAT, which I will explain in due course.
Who are you appearing for, Mr. Sehgal?
I'm appearing for Vadhavan, Dheeraj Vadhavan.
So that is, Mr. Vadhavan is the successful appellant before the NCLAT.
Okay.
So he is the person who succeeded in NCLAT, having lost in the NCLT. My learned friend says that he's in jail, etc. That may be the case. But I am now seeking in respect of a company which is not the subject matter of this appeal, but where parallel proceedings are going on. And I'll just explain that position.
How can we pass orders against that company here?
No, so I'll just explain. It's against the RP because the RP has recognized my claim And he says that because of this pendency of the specialty petition over here, where a status quo, the civil appeal, where a status quo order has been passed by your lordships, but no stay granted by this court, he has pared down my claim of 1180 crores down to ₹1 on a notional basis.
But
so I am not being given a seat.
But that order you will have to independently challenge.
No, there is no order as such. The COC is that. I'll just explain it to the court. But if the question is whether we want to do it today or on Friday, that's the only issue.
We'll keep it since he wants a little time.
Then your lordship will call it out on Friday.
Yes.
Lordship, please.
Sorry. Anyway, would your lordship take it up on Thursday? Because the NCLT has put it today. Today they adjourned it.
Inform them. Then we have taken it up.
We'll inform them. We'll do that. Grateful.
31.
This matter, my lord, I'm seeking a short accommodation. Mr. Giri is appearing in this matter, my lord.
We'll take it next week. We'll start the income tax board now.
Yes.
I thought we'll finish in.
Well, it's an item 1. Item 1. I just want to mention.
I need to. May lordship just take a minute before my learned friend starts on the issue.
Yes.
Your lordship, in this case,
Well, it's in item 1. I just have a small thing to say. Well, I appear in item 1.33. Well, that's SLP number 4863 of 2023. I filed an IA 109308 of 2024 pleading for detagging, Malad. And the reason for detagging.
No, let them let's not repeat it again and again. Every time they scuttle it this way. Let them send a mail. We will inform the court if whether it will be detagged or not.
Just it's not getting over today. Just send a mail to him.
Whoever wants to do anything on IA, please mail to us.
Just send a mail to the NHG. He'll examine it and he can tell us it has to be detagged. We'll detag it day after.
Very well. Very well. I'm so grateful.
May start now.
Yes.
Sorry.
Oh, mera.
May I mention, lordship? Just for the purpose of housekeeping, lordship. Lordship, there are more than 630 matters listed before your lordship. And these are arising from various high court, and each high court has given judgment in respect of assessment year based on those particular issues. So, if you are I've just given a one page, your lordship.
But I will not die. Let me clarify what my friend.
Give me
one minute. Let me respond. I have given already. I have circulated even before vacation. My lord, the principle of law will remain the same, one way or the other. Either we succeed or we lose, and it can be applied, my lord, for every assessment year. I have given a brief note already to the court and to my friend.
Just give me one.
But no, give me one.
What is the date on which we had last heard the matter, because we can track our notes then?
No, it was heard March. Was heard last. I'll just give the date, my lord. 2/5/2024. And it was heard for more than one and a half days. My friend is now trying to divide. But let me assure my friend.
Which is that substantive hearing before the 2nd of May?
Not we have 3 dates: 19/3/2024, 23/2024, and 2/5 very briefly. But these two are substantive hearing: 19/3/2024 and 23/2024.
Yes, I got it. 19 plus.
Money was on.
May I just explain you? Just find you.
Let him just at least open.
Just 1 minute. I will not take more than 1 minute just to explain. These are 630 odd petitions.
Yes.
And there are 5 assessment years.
Yes.
5 different assessment year.
Yes.
Issue arising in 12-13 and 13-14 is different than what is in 14-15, or the reasoning given. And 15-16 and 15-16 is different than 12-13, 13-14. And 16-17, 17-18, there are 2 issues. Different high courts have taken on that issues. By and large, all high courts are in favor of the revenue assessee, except in 12-13, 13-14, where all high courts are in favor of the assessee, except Delhi High Court and revenue issue. So when my friend is addressing the court, my suggestion will be, only request will be, just for the purpose, because there are 31 advocates which are lined up for arguments.
Now, when I tried to reach out to each one, I could find out somebody will be arguing for 12-13, somebody will be arguing for 14-15, or somebody will be arguing 15-16. So there is bound to be a little confusion because one will be addressing the issue which is relevant for 12-13, and then next advocate will be arguing the issues in 16-17-17. And these issues are different. And that's why I just made a 2-page chart on this issue, that these are the 4 categories in which this petition need to be divided. And based on that, then issues by 12-13, 13-14, these are the High Court judgment which will be subject matter of our decision. That's all.
Okay. Since you have prepared this short, this is your note, no?
Yes, sir.
May I assist, my lord, a straight answer? But fortunately, even though there are 31 councils, the ASG is only one in this matter. So for all the 5 versus 20 years. As I can solve this.
Ultimate Ramayana, Ram was supported by the army, but when he faced Kaldosan, he lost alone.
So 1:31.
He doesn't want a compartment in this manner, it is up to him. But we will proceed in this compartment.
When I close the submission, when we close the submission.
It's kind permission. 15-16 is something which is completely unconnected because what we are concerned with today is.
So we'll deal with it separately.
Yes.
Because that is not something which is related to TOLA, COVID at all. These are all under the old scheme, regular reassessment.
All right. We've got now the drift of yours.
We have filed a brief note on this year-wise. Lord, I will deal. The apprehensions of my friends will be well addressed. Let them not jump. I have addressed it in my brief note too. All the 5 years I have captured it. But please, so let me first place the legal position first. And then we'll apply it every year. That's Lordship will decide the legal principle and its application per assessment year. That's the matter. Matter ends there. But may I start now? Will your Lordship be kind enough to let me recapitulate in 5 minutes, Lord, what the issue is and then show the provisions of law? Your Lordship would permit.
Yes.
Lord, we had an old regime of 148 prior to 1/4/2021. The cutoff date is 1/4/2021.
Perhaps for the 3rd or 4th time you are.
In fact, I was telling Mr. Sridharan, Lord.
So now I'm not making fresh notes. I'm reading what you had said last time.
See,
so if there is something last time, I remember in May, I was adding in small handwriting what additional things you were saying. So I'll do the same thing now in my notes.
Please, Lord.
I can't read your own notes. I can read half an hour.
In the lighter vein, 2 matters you need to stake off in your Lordship's court in spite of our best effort. One is TOLA, another is JET. We don't know which is pulling the other.
Now, JET we will take up next week for sure. Today, next 2 days we'll finish off TOLA.
I will not take
complete TOLA.
It's a simple legal issue. My friends need not apprehend whatever. I have only one question needs to be addressed. Bottom line question is whether TOLA has to be read into the proviso to section 149, new 149 or not.
All right, now you can just start.
That's all.
Give us a quick backdrop of the matter.
Will your Lordship be kind enough, my Lord, to come to?
So you were saying that prior to 31/3/21, reopening was governed by sections 147 to 149 and 151.
Yes. And
4 years was the normal period and 6 years the extended period.
Correct. Will your Lordship, therefore, I'll just recapitulate that. Page numbers. Lord, 352 is 147. Page 352 is section 147.
And 354 is 149.
355 is 149. Where, my Lord, who is the approving authority? And my Lord, 148 is at page 354.
Yes.
So, my Lord, income escaping assessment. Two divisions, less than 4 years, my Lord, 4 years and 6 years. 6 years, my Lord, it's the extended period if there is suppression, etc., etc. That's a broad classification. But my Lord, what is important is, please come to page 420. Supreme Court in GK and drive shaft. But there was no procedure involved after an 148 notice was issued and before, my Lord, a commencement of an assessment proceedings. So GK and drive shaft, my Lord, at page